Petition is allowed.
File.
I'll sign it later.
May it please, your
Yes,
lordship. My lord, I may be allowed to move a matter on Friday evening.
it is okay.
I have similar prayer, Lordship. Obligation.
I have also, my lord, more from. And others, my lord, after vacation. I am.
I recommend item number 15, my lord.
Hmm.
My lord, may be taken after vacation, my lord.
Why?
My lord, I have taken consent from the
Have
others.
you submitted your mention slip?
I have taken consent from the other side, my lord.
Consent is a different thing. You have to submit a mention slip in advance. You are Mr.
K. Kolita,
appearing on behalf of
petitioner, my lord.
K. Kalita. On request made by Mr. K. Kalita. Learned counsel for the petitioner. Release the matter after summer which.
Obligation, my lord.
Very clear, Lordship. Which I recommend on item number 26, Lordship. I am for the petitioner. I have taken consent from the other side. Here, Lordship, I have to suppose to file an affidavit in reply. Affidavit is ready, but because of the hard situation, the petitioner could not come down.
On
then
request
after the
made on
vacation-
behalf of Mr. A. Dekal, made by Mr. A. Dekal and the counsel for the petitioner, list after summer vacation.
After vacation. Item 26.
Item
26. Deeply obliged.
May please, your lordship. Item number 34 and 35, lordship. It may list after vacation, my lord. Because of the death of the older son of Ramchandra Sikari against council.
It's the implementing petition.
Rejection.
implement petition, you can move it. You can move it unless there's some objection. Wait for some time. We'll allow the implement petition unless there's some objection from the other side.
Right.
No,
If there's some objection, then we'll adjourn the matter.
Please, lordship.
Hmm.
So I'm paying for listing of a petition motion on Friday. I'm paying for an unlisted motion today.
Why?
My lord, the same matter, same issue, my lord, issue relates to the MBBS students, my lord, who are under the EWS category. Same issue is before your lordship in item number 39 of today's motion supplementary list.
Hmm.
So, my lord, both cases can be covered under
Item number?
39 months. Motion, my lord, supplementary.
Hmm.
We are also having the same issue. These petitioners are also having the same identical issue. Same decision of the state government has been challenged. So, my lord, if it can be taken up today, perhaps my lord, common order can be passed in both the matters.
Is it ready?
Yes, my lord, we have already filed, and the filing number is also there.
We'll see.
Public.
Item 1 of daily list for withdrawal.
All the taking order already complied, my lord.
Mr. Kia Patri, the counsel for petitioner,
Passing in order.
submits that the respondents have complied with the directions passed by this court. And therefore, he is not pressing the present contempt petition.
I'm for one. I'm the force the sole respondent.
Still, and counsel appears for one. Contempt petition is accordingly closed.
2.
In this case, my lord, complied, but the appeal is rejected. I have to file, my lord, press it. Same thing, same order.
Mr. Same order. You are appearing for?
Sole respondent.
For the
Sole
sole, yeah, you say sole respondent.
Obliged.
3 and 4 motion.
Next is the lordship.
Yes.
But the petitioners, my lord, they are assistant teacher, my lord, and master of LP school, my lord.
Yeah.
And their name was recommended, my lord, under 2011 Act.
Yeah.
recommendation and recommendation, my lord, page 67 onwards, my lord. Although, my lord, they were recommended, my lord, under 11 Act, my lord, their service have been provincialized, my lord. Under new Act, my lord, page 97, my lord, as tutor. And similarly situated teachers, my lord, whose name recommended, my lord, they are, my lord, provincialized as regular teacher. We have been provincialized as tutor. And
Yes,
so, my lord, at this case, my lord, notice may go in this case, my lord.
First of all, Lordship, their repetition is not maintainable because they have they are 145 read petitioners. They were from different districts. They are seeking conciliation. The school was established on different dates. They were appointed on different dates, Lordship. Cause of action arose on different dates. And how can they club together in a single petition, Lordship?
Yeah.
That cannot be, Lordship.
My lord, the issue is same, my lord.
Issue-
All
issue may be
teachers
that-
are
it's not
No,
the
issue
same.
is
You're
not
all
that.
from different districts,
Cause of action is
different
different.
orders.
And cause
How
of action
can
is
you
also
have
different.
how can you have
My
a,
lord, cause of action will be same, my lord. All
Yes, sir, it was separate
teachers, all
petition.
teachers are have been,
Mr.
my lord,
Ali, course of action may be the same.
lost,
Different orders, different districts.
lost.
How can we take up this?
Different
in
schools.
one writ petition?
Not otherwise, my common cause of action, therefore, my lord.
No, similar cases were dismissed earlier, Lordships. They were directed to file separate writ petitions, Lordships.
That's
Similar cases.
Unless you want a dismissal order and
No, no,
directing, it, then you can withdraw and file afresh
Individually, my lord.
individually.
Lost.
R. Ali Leonard Council for petition. Press for withdrawal of the state petition with liberty to file afresh. Stop. Mr. Chowdhury, you are appearing?
VDC night.
Who's appearing for the respondents?
Or respondent who quit it.
Mr. G. Beku, Leonard Standing Council,
My lord, so many respondents.
elementary education appears for the respondents, 1 and 2. This is the problem, Bachali, Baksha,
Yes, my
Partuta,
lord.
Chirang,
This is the problem.
Himaji, Dhumri, Kamrup, Kokrajhar, appears for response 1 and 2. Stop. Writ petition is accordingly dismissed on withdrawal with liberty as paid for. In the second writ petition,
Same, my lord.
My lord.
same order.
With liberty, my lord, to file afresh.
Five.
One
Obliged.
minute. Beku, you are appearing in the second writ petition. 1 and 2, same one. One and two. But make it separate orders.
Obligement. Your lordship, I may be allowed to withdraw this matter, your lordship, I have transferred from the client. I'm T. Deori, your lordship.
You want to withdraw it?
Yes, your lordship.
Mr. G. Deori, Leonard Council for petitioner, press for withdrawal of this writ petition. Mr. G. Beku, Leonard Standing Council, Elementary Education, appears for respondents. Appears for all the respondents.
I'm deeply obliged, your lordship.
Petition is accordingly dismissed on withdrawal.
Obliged, your lordship.
Six.
Maybe it's also.
Yes.
In this case, I am praying for transfer or disciplinary action against a teacher, Lordship.
What is it?
For disciplinary action or dismissal of a teacher or transfer, Lordship, because the teacher was causing serious cruelty, torture upon the students. And there is a prayer from the guardians of the students, and accordingly, the private respondent, the teacher was transferred to some other school, but he filed a requisition before this honorable court challenging the mode of transfer because as per the new act, he cannot be transferred like that. So his transfer was restored. And after joining the school again, he is continuing with his torture with the students. Therefore, the guardian of the petitioners submitted one representation to the local elementary education officer. It is at annexure 4, page 25. What may I kindly see? Page 25, Lordship. With due respect and humble submission with the guardian of the students of Jona.
Where is the interim order passed by this court?
No, Lordship, it is for the first time, Lordship. It is
No, in that writ petition.
in that case, Lordship, the transfer order was set aside. Then he joined in the school again. And thereafter, he continued with the torture of the students. So,
The guardian submitted one representation demanding transfer of the said person or appropriate action against that person.
Who are the petitioners in this writ petition?
Another,
Who are the petitioners?
in this petition, they are
Yes.
the guardian of the student.
Are these the same guardians who made the representation?
Your Lordship.
Are these the same guardians who made the
No,
representation?
Lordship. In earlier petitions, earlier representations, they were Monica Parvin, Abdul Malik Mullah, Bahatan. And now these are different. Monica Parvin is their Lordship, but the one is common, but other.
I don't know what is going on.
Lordship, see page 26 to 28. These are all the persons who has applied for, paid for transfer of that person. Page 25, it starts.
Then
Lordship, can we issue notice in this case today?
what notice? What notice?
Lordship, my prayer in this case is, Lordship, kindly see my prayer.
Is this court going to transfer the respondent,
No,
or the authorities are going to take steps?
I'm not properly getting what.
What is your prayer in this writ petition?
My prayer is to either to transfer that person by following due procedure of law or proceed departmentally.
How can this court pass that order? Tell me, how can this court pass that order? Yes, Begu, what do you say?
May I read my representation once, Lordship, page 25. With due respect and humble submission, with the guardian of the students of Jonosatona LP School, Kepalkhari, Helapakhri, under Moza Elementary, Matia Elementary Education Block, Matia Gwalpara, have the honor to state that assistant teacher of the school named Sri Zomeruddin Ahmed is most arrogant, mischievous, and evil-spirited person who has no capacity of teaching the students. His demonic behavior has created an enormous and feeling of fear atmosphere among the students. He often makes tremendous assault of the students in the name of controlling the students. Just around 17.
What I read. Yes, Begu.
This is not the appropriate forum, my lord.
This is not the appropriate forum, that's what I'm saying. You approach the appropriate authorities.
Because I made application before the authority, but they have not taken any steps. It is application dated 18 April 2023. Now it is June.
Is this the only authority?
Yes, Lordship. Lordship,
Are there no other authorities higher than him?
yes, Lordship. Lordship, may take up the matter after vacation, Lordship.
No.
Then-
I'm not keeping this pending. I'll allow you
Because
to
this
withdraw
authority
to
received-
approach the appropriate authorities, that's all. Giving you liberty to approach the appropriate.
Yes, Lord.
Mr.
Ours, my Lordship.
R. Shamal, Leonard Counsel for petitioner, press for withdrawal of this petition with liberty to approach the appropriate authorities. Mr. J. Bikul, Leonard Government Advocate, appears on behalf of
Respondent number 3.
respondent number 3, and Mr. J. Bikul, Leonard Standing Counsel, Elementary Education, appears for
1, 2.
respondent
1, 2, 4, 5, and 6.
1, 2, 4, 5, and 6. Every petition is dismissed on withdrawal with liberty aspect.
7.
May I please, your lordship? In this case, the petitioner number 1 to 8 are the teaching staff of the higher secondary school, my lord, and 9 is the lower division assistant and 10 is the grade 4 employee. The petitioner school was established in the year of 1961 and up to high school level. The high school level was provincialized in 1985. The petitioner school is situated in the heart of the tea garden, 4 tea garden, and 65% of the pupils of the tea garden area, tea garden area, and the petitioner school, the HS The higher secondary level was adopted in the year of 1996, and from 2001, my lord, the first best of the higher secondary student appeared in the higher secondary examination. From 2001 to 2023, all the continuously all period they are successfully 80% pass percentage. But the teaching staff of the teaching and non-teaching staff is not regularized till date, my lord. And the higher secondary level was higher secondary section was accorded approval in the year of 2002 after several communication made by the petitioners, headmaster, and the managing committee of the school, my lord. Annexure 11, my lord, where the annexure 11 is 68, my lord, where the 212 numbers of higher secondary school as proposed is I am director the government of is secondary
Page,
education
page.
is page 68, my lord. The original page is 68, my lord. 68 approval order, my lord, where the 212 numbers of school was accorded approval, where the petitioner school was appeared in 112, Hailakandi, Monasara High School, Monasara Higher Secondary School, my lord.
Serial number?
112, my lord. Page number 71.
Yes.
But when the when the school of the petitioner was going to provincialize under the 2017 Act, my lord, the headmaster of the school, as the no principal was the post was created, the headmaster of school submitted the all relevant documents to the inspector of school for provincialization of their service, but the inspector of school did not forwarded the relevant documents to the district scrutiny committee, Hailakandi, as they are left. Thereafter, the petitioner, all the petitioner filed and several appeal representation before the respondent authority to regularize their service, my lord. That is, start from Annexure 13, page 75, until that no steps have been taken by the government to regularize their service, as they are working since last 20 years, my lord, and all the teachers who were qualified and they have this they have postgraduate teacher, and so petitioner here we're praying for regularization of their service, my lord.
Yes.
My notice would go at this stage, lordship. Notice would go.
Notice me go, my lord.
Third witness. A. Bajar Baral and counsel for the petitioner. Petitioner. SMT Chief Leonard, standing counsel,
For secondary education, lordship.
secondary education.
District elementary education of security.
One,
Type 2
two,
elementary. 2 is no more true. The special commitment is no more there, lordship. That may be stuck up.
that she'll have to make an application.
1, 2, 3, 4.
1, 2.
1, 3, 4, 5
1,
and 6.
2, 3, 4,
5 and 6.
5 and 6.
No, 2 I cannot. There is no post of special.
Anyway, you take it. Later on, she'll make an application.
Yes,
One,
but the
two, three,
special
four,
office
five.
commissioner has accorded approval, my lord.
Petitioner to take steps for service of notice on this phone number 7 by registered taken within 1 minute. This is the matter after
6 weeks.
4 weeks.
Must
eight,
Lordship. Lordship, I want to withdraw the petition, Lordship, with liberty to file afresh.
Mr.
M. Rana on behalf of DP Chalia.
M. Rana, Leonard Counsel, appearing on behalf of Mr. T.B. Chalia, Leonard Counsel for the petitioner, press for withdrawal of this petition, with liberty to file afresh. Mr. A. R. Davida, Leonard Standing Counsel,
Higher Education Department.
Higher Education,
Correspondent number 1,
appears for the respond number
1, 2.
1 and 2. The petition is accordingly dismissed on withdrawal with liberty as well.
9,
May it please your lordship. Lordship, here the advertisement was there of 12th August 2022 at Annexure 1. My lord, what has happened was a post for grade 4 and educational qualification was class 8 pass and the petitioner here is also class 8 pass. But my lord, as for the advertisement, there was no conduction of computer test. But when the petitioner applied, my lord, they conducted a computer test without the same being applied, without the same being applied in the advertisement. And moreover, my lord, at paragraph 6 of my writ petition, I have clearly stated the selection committee who was there as the principal, his tenure had already been over. And still he said in the interview for the Viva votes. In fact, my lord, a similar writ petition has been filed before this honorable court, and the honorable court was pleased to pass an order. So, my lord, similar order may be passed, my lord. That I have annexed an order that is at annexure 7, page 29. I have also filed a representation before the
Same advertisement,
same advertisement, same issue, my lord.
1 minute.
My lord, at page 29, the order starts, and at page 30 is it. My lord, the challenge pertains. May I read, my lord?
Oh.
Same college, same advertisement, my lord. Same, different candidate only.
So you don't want final orders to be.
My lord, and a similar order would do, my lord. Because in fact, my lord, the same matter is pending, where the Honorable High Court has directed to consider our representation before the selection committee, and they should not come up with the order of the selection committee before the taking the leave of the court. My lord, it's in paragraph 8, my lord. May I read, my lord? Page 31. Since it transpires that the Director of Higher Education is yet to pass order on the recommendation of the selection committee, this court is not inclined to pass any blanket order of stay. However, to balance the equities, it is directed that after application of mine by the director on the recommendation of the selection committee, no final order be passed by the department without the leave of this court. The court also directs that since representation has been stated to be filed by the petitioner, same may also be considered by the director at the time of consideration of the recommendation of the selection committee. To facilitate such consideration, petitioner shall give liberty to file fresh copy of representative director within a period of 3 days from today. List this case on soon. I may also have to give us the same order, my lord, because my representation also is pending. So I may give fresh representation.
Where's your representation?
My lord, annexure 4,
Page.
page 25, my lord. And my lord, where annexure says to the Director of Higher Education, my lord. The receipt is on 30th/4. My lord, bottom is a receipt. 34/2023.
Till now, not.
No, it's not been decided yet.
Yes.
Disposed of, lordship, this representation may be directly disposed of.
Well, disposal, we'll keep it pending.
My lord, disposing of would be because the similar line is there and
Yes,
already, my lord,
That may be
taken has been.
similar and.
You're Mr.
SP Sharma, my lord.
But Mr. S.P. Sharma, learned counsel for the petition. Stop. By this writ petition, the petitioner is challenging the selection process of grade 4 post in
In my lord, Basoi Banikanta Kakuti College.
House P. Panikanda Kakuti College, Naugam, Barputa. Which was initiated by the advertisement dated 12/8/2020. Stop. The grievance in the of the petitioner is that in the selection process, some irrelevant and extraneous factors were taken into consideration by way of taking computer application test, correct?
Yes, my lord. And also non-consideration of the form of computer application.
What is it?
My lord, they were taking form of computer application, which was not part of the advertisement, my lord. That was an external factor, my lord. That was not even a part of the advertisement.
Then by extraneous factors, in as much as computer typing tests
Yes, my lord.
for grade 4 candidates were taken, correct?
Yes, my lord. Which is not part of the advertisement.
Which is not a part of the advertisement, which is not a part of the stipulation made in the advertisement. Stop. Further, comma. It is the case of the petitioner that the term of the president of the governing body of the said college had expired in January 2023.
My lord.
And therefore, the constitution of the selection committee by itself stands vitiated. Stop. The petitioner also made a representation before the
Director of Health Education, my lord.
Director of Health Education on what date was it?
3/4/2023, my lord.
On 3/4/2023. Stop. Para. Issue notice. Mr. A.R. Tabindar, Learner Standing Council,
Higher education.
Higher Education, appears on behalf of respondent number
1 and 2.
1 and 2. Stop. Petitioner to take steps for service of notice on the respond number 3 to 8 by the state post AD within 1 week.
My lord.
Within 1 week from today. Stop. Respondents are allowed to file their respective counter affidavits. Stop. Para. In the interim, it is directed that no final orders will be passed by the department with regard to the selection of grade 4 post of
Without the leave of,
what college was it?
grade 4, my lord.
Of so and so college, huh? Without the leave of this company. Stop. That
I'm-
must be,
The director, for directing my representation, my lord.
The director of higher education of like respond number 2 shall also consider the representation made by the petitioner dated 30/4/2023 before making any recommendation of the selection committee. Stop. Please, the matter after
My lord, may I just please to tag this matter with 2658?
along with.
Because it's a similar matter, similar issue.
PVC number
2658 of 2023.
2658 of 2023.
That's always. 10.
May I plead your lordship? Lordship, in this case, the petitioner died on, the father of the petitioner died on 20/10/2008. Thereby, he filed application on 26/11/2012. My lord, the communication is there, my lord, in page number 16. The petitioner submitted his application before the DEO, submitting all the documents and application. Despite of that, my lord, the GLC has not yet considered my case. So my prayer is that your lordship may direct the respondent GLC to consider my case as early as possible.
Why did you submit your application so late?
Application to the DEO. DEO, district.
Why was your application delayed?
Page the,
Your father died on 2008. You met your application in 2012. Where's the explanation for the delay?
Lordship,
Yes, I can.
My lord is correctly pointed.
DLC can consider the matter.
My lord, even my lord, that application, my lord.
She is appearing as a junior counsel. Let us give her some relief.
My lord, that part.
Paying is just sitting down. He knows he has no case. So he's letting his junior appear in the matter, isn't it, Mr. Paying? Taking a good risk.
That's my lord.
Let the DLC consider
My lord,
on its own merits.
my lord, before
On its
that,
own.
my lord, that concerned DO may be directed, if record is available, my lord, you place before that. Here.
Hurt MS,
A Pine.
A Payang learned counsel for the petition. Also hurt Mr.
And for.
A Fukan, learned standing council elementary education for respondents, 1 and 2. 1, 2 and 4.
Yes, sir.
And Mr. V Cycle and Governor Advocate for respondent number 3. Para, the father of the petitioner, while working as headmaster of Azarguri Dorki LP School, Kamat North Lakhimpur, died in harness on 2010-2008. Thereafter, where's the application?
Applications is page number 16.
The petitioner made an application. This is not an application, page number 16, annexure E.
Annexure, Lordship,
This is a statement of marks,
Annexure.
My lord, page 16.
page 17, annexure F.
Last
Yes,
page, my lord,
lordship.
17 is the original, my lord.
Annexure F is page 17 here.
My lord, that is the original, 16.
17, page 17, sorry, Lordship.
Made an application before the district elementary education officer, Lakhimpur, North Lakhimpur, on 26/11/2012, praying for appointment on conditional grounds. Grievance of the petitioner is that his case is, is it his or his case is yet to be considered. But is yet to be placed and considered by the concerned district scrutiny committee, district level committee.
Yes, Lordship.
Para, considering the limited prayer involved, this writ petition is disposed of, directing the district elementary education officer, Lakhimpur, oblique respondent number
Excuse me, 4, my lord. My lord, 4.
Respond number 4. To verify the records. And thereafter, place the application of the petitioner before the concerned district level committee for consideration of the case of the petitioner for appointment on competition grounds. Thereafter, the district level committee shall consider the case of the petitioner on its own merits
My lord.
and in its next immediate sitting. So, with the aforesaid obligations and actions, suit petition will be disposed of.
Applause, madam.
11.
So petitioner is a regularly appointed, after selection, he was appointed as a teacher in a LP school. Lordship, thereafter, Lordship, GPF account has been opened. GPF account has been opened. Thereafter, Lordship, petitioner service has been terminated. That was set aside by the Honorable Court. Thereafter, petitioner service has been regularized in 2015. Lordship, thereafter, again petitioner service has been regularized on 2022, 39/2022, page 51. And petitioner was directed to give an undertaking that petitioner have to accept the new pension scheme. So if GPF account has been opened, page 36. Page 36 is the GPF account, Lordship. Kindly see page 36. Page 36 is the GPF account. 2021 Lordship, 2001 Lordship.
Notice will have to go.
Lordship, at least no notice will go.
But Mr.
SK Goswami.
S.K. Goswami, learning counsel for issue notice. Mr.
Respondent
Khan, learning standing counsel,
Respondent one, Your Lordship.
elementary division appears for respondent number 1, and Mr. B. Chowdhury, learning standing counsel, BTC
2, 3, and 4.
appears for respondents 2, 3, and 4. Finals,
But, Mr. H. Alia's name may be.
Mr. Chalia, learning standing counsel final appears for respondent number 5. Notice on respondents are complete. However, extra copies. Respondents may file their respective counter affidavits, list the matter after 4 weeks.
Oblige.
12,
Lordship, matter may be passed over for the time being. My senior legs in court number 4.
Yes.
My lord, in this case, my lord, petitioner's claim was rejected by the DLC due to, my lord, the lack of submission of, my lord, the next of kin, my lord.
Where is the next of kin?
Yes, my lord, my next of kin, my lord, page 13, my lord. It was, my lord, 13, my lord, dated 22/12/2016, my lord, and my application, my lord, at page 18, my lord. It is subsequently, my lord, 29/12/2016, my lord. I submitted it along with the next of kin, my lord, but here, my lord, TLC, my lord, page 23, serial number, my lord, 10. Serial number 10, my lord, next of kin not submitted along with
Page?
application, my lord. Page 23, my lord. Serial number 10. Next of kin certificate not submitted along with application, my lord. And my lord, I beg to refer, my lord, another candidate, my lord, page 24. Serial number 19, my lord, same, my lord, remarks, my lord, 19, Masud Ahmed Borbuya, next of kin certificate not submitted along with the application, my lord. And for
1
him, my
minute,
lord,
that DLC recommendation, serial number,
serial number, my lord, he is, my lord, page 24, my lord, serial number 19, my lord.
yours is serial number 10.
My serial number 10, my lord. Next of kin certificate not submitted along with application. And his, my lord, serial number 19, page 24. Next of kin certificate not submitted along with application, my lord. And my lord, he approached before your lordship, and your lordship was pleased to pass the, my lord, judgment and order, page 26, my lord. Your lordship provided, my lord, to reconsider, my lord, and it was directed to submit once again, my lord, next of kin certificate.
Yes. Okay.
My lord, next of kin certificate is the prime document where my lord petitioner can, my lord, come before this court by seeking the compassionate appointment, by saying that he is my holder, my lord. If my lord, next of kin certificate is not enclosed, my lord, the finding of the concerned DLC is, my lord, not wrong.
Did you enclose your next of kin certificate?
My lord, I am, my lord, submitted, but they are, my lord, somehow, my lord, maybe may misplaced, my lord, and disputing, my lord. Your lordship, my lord, observed, my lord, page 27, referring another judgment and order.
If that is the submission, my lord, it is the disputed question of facts, my lord. If he submitted it lost by the authority, my lord, that is not a state question, my lord. In fact, it is the allegation to the concerned authority.
Page 24, my lord, I am not giving, my lord, going to the disputed fact, my lord, at this stage, because, my lord, this issue is already settled by this honorable court, my lord, that without going to all this technicality, my lord, the application should be, my lord, considered on merit. And your lordship passed this order, page 27 on 22/6/2023, taking reference of another judgment and order of this honorable court, my lord, and provided to reconsider the claim of the petitioner, my lord, and it was also directed to the petitioner to submit the original next of kin certificate. Page 28, my lord, this last penalty made paragraph, my lord, accordingly, the petitioner is directed to produce the next of kin certificate in original to the concerned authority, and thereafter the case of the petitioner shall be placed in the next immediate sitting of the concerned DLC for reconsideration of his case for appointment on compassionate ground in accordance with law.
Yes, I can.
My lord.
It is completely, my lord, covered.
Can dispose of on that line only. Heard Mr. M. Barbara, let me comfortable. Also heard Mr. J. B. Good, Leonard Standing Council, Higher Education,
Elementary education, respondent number 1,
Elementary Education for respondents,
3,
1,
5 and 6.
3, 5, and 6. And Mr. P. Cycle and Governor Advocate. For respondents, 2 and 4.
My lord, sorry.
2 and 4.
My lord, 2 and 4, my lord.
2 and 4. For Father of the petitioner, let Sirajuddin Chowdhury, while serving as headmaster
Expired
at Rangbur Bolipur ME School in the district of Hailakandi,
relationship with expired.
died in harness on 20/10/2016. Stop. As the petitioner was qualified, he made an application for appointment on compassionate grounds on 29/12/2016 by in the prescribed format. Along with all necessary documents. Stop. However, as the case of the petitioner was not considered by the DLC, the petitioner approached this court by filing WBC number 5236 of 2019, which was disposed of by order dated 26/7/2019, directing the respondent authorities to place the matter before the appropriate authority for further consideration within a period of 1 month from the date of receipt of a copy of the said order. Stop.
In the next DLC, 1 month order in the next DLC, where the earlier.
No, 1 minute. Stop. Thereafter, para. The district level committee, Hailakandi, in its meeting held on 5/10/2021, could not recommend the case of the petitioner. No, rejected the case of the petitioner on the ground that next of kin certificate was not submitted with the application. Stop. Para. It is the case of the petitioner that he had obtained his next of kin certificate on 22/12/2016 and had submitted the same while making his application for appointment on competition grounds. Stop. Learned counsel for the petitioner, placing reliance on the order dated 17/1/2022, passed in WBC number 217 of 2022. Submits that the case of the petitioner may be remanded to the concerned DLC for reconsideration. Para. In the order dated 17/1/2022, passed by this court in WBC number 217 of 2022, this court had made an observation that the law of compassionate appointment is not a regular recruitment, and the authorities are looking into the issue with some compassion, as it is a claim for compassionate appointment, and the only requirement of law is to see an interstate comparison of the financial status of the applicants, so that the worst of the candidates is offered appointment. Stop. After hearing the learning counsel for the parties, this court is of the considered opinion that the ratio laid down in the order dated 17/1/2022, passed by this court in WBC number 217 of 2022, can be applied in the present case, inasmuch as the DLC, which held its meeting on 5/10/2021, rejected the case of the petitioner only on the ground that the next of kin certificate has not been submitted. Stop. Accordingly, the petitioner is directed to produce the next of kin certificate, in origin, to the concerned authorities, and draft the case of the petitioner shall be placed in the next immediate sitting of the DLC, of the concerned DLC, for reconsideration of his case for appointment on compassionate grounds and in accordance with law. With the aforesaid observations in the actions, with petition it is possible.
Development.
38 of supplementary list. Motion.
The next one.
Please, your lordship, we taken up this matter after some time, lordship.
Why?
Senior counsel is on Lakes, lordship, court number 1.
Otherwise, in similar cases, notice has been issued. This is the order. Same issues.
Already, lordship had heard this matter earlier,
Then we can issue notice if notice has been issued.
lordship.
We can issue notice.
Lordship, for interim, lordship, earlier occasion,
In fact,
lordship.
in that, the coordinate bench of this honorable court, refused to grant an interim order.
Okay. After some time.
Right.
Obliged, lordship.
39.
May I please, my lord, this has become a perennial problem now. What is happening in the state is, my lord, after the amendment of 15(6) in the article 15(6) was incorporated, giving 10% quota to EWS. Within the general, my lord, 10% is carved out for EWS. Now, whereas, my lord, for medical admissions, both MBBS and PG, the competent authority, my lord, took a decision, okay, we will give them 10%, but we will increase the total percentage of seats by 25%. To give that EWS, we will increase it by 25%. This was in 1920. They did not do it. We came up, the matter was filed before my lord. My lord directed them to do it. They did it. The next year, my lord, 2021, same thing. In EWS was being given, but this increase was not being given. We came up before my lord. This honorable court again protected us, saying that 51 odd seats. This was supported by the union government, NMC, National Medical Council, and as well as the state government. 21-22, same thing. My lord. Nothing was done. Again, we came up. 22-23, also, my lord, last occasion, because 1 year there were two because of COVID. But the last occasion also, this was not being given. This honorable court directed and 51 seats were added and given. Now, what I have understood, my lord, is that the 51 seats that's added in a year, in the next year, they deducted from the seat matrix. We are only concerned with the state quota, my lord. There are, my lord, around 600 seats. 300 will go to the central government pool. We are not concerned with that. But the state quota, 300, we are concerned. So therein, you have to give a 25% increase. It comes around to, my lord, 51, 52 odd seats, my lord. This time also, my lord, the seat matrix is not out. It will be out very shortly. Now they have taken up the whole scheme of counseling has changed. It will be done in the center. It's good for the children, my lord. It's good for the candidates. It will be done by the central government, NMC. There will be 6 rounds of counseling. And in each round, my lord, I get a seat of my preference. Then in the next round, if there is a better seat, I can surrender and I can participate in all those 6 rounds. Earlier, that was not being permitted. Now, be that as it may, the only problem here is, they say on the day the counseling starts, the seat that are fixed, my lord, we will not change that. So today, my lord, the state has, well, I have said categorically, the state has told us that until and unless there is an order from the court, we will not add the seats. Now, my lord, I'll take my lord through the thing. If my lord can come to straight away to page, my lord, 40. This is, my lord, of 2019. This was, my lord, for MBBS, but this was adopted for the PG also. The relevant, my lord, is at page 41, clause 3. For 10%, my lord, the top portion, for 10% increase in seats of EWS quota, the following are the guidelines to facilitate its implementation. 3. My lord, page 41. In order to implement 10% EWS reservation quota, the increase in seats has to be effectively 25% of the current intake to ensure that the existing number of general and other quota are not affected. Thus, a college with current intake of 100 seats would need to add 25%, that is additional 25 seats. Then what happened, my lord? If my lord comes to page 45, a writ petition was filed before this honorable court. Relevant is 63. My lord, 24/8/2020. My lord, after discussing the issues, this honorable court, my lord, finally came to a conclusion at page 66, para 9, my lord.
Yes.
From the facts and figures as regards the availability of seats for undeserved category as regards the available and agreed upon by the learned senior councils for the parties for the year 2019-20 for the PG degree and diploma courses in medical sciences in medical colleges Assam, it is discernible and apparent from the number of seats subject-wise which have been approved by Medical Council of so-and-so for increase in the year so-and-so as provided in para 58 at page 56 and 57 of the affidavit in opposition of the Medical Council of India, that increase would approximately be 25% over the seats available for the unreserved category for the year 2019-20. My lord, this writ petition is number 3007/2020 because my lord will find a reference of this all along. Then finally, my lord, this honorable court directed at page 67, para 12. The figures as indicated in para 58 at para 56 and of the affidavit in opposition of so-and-so shall not be read to also include increase in seats that may have occurred because of some subjects having been started to have been functioning, some colleges from the year so and so, as well as because of some more medical colleges started functioning, and due to conversion of certain seats from so and so, the admission process be completed on or before so and so, by otherwise following the due procedure of law. So, my lord, then the matter was not disposed of. An interim order was passed because you have to give this 25%, 1920, whatever was there, give 25% over that. And accordingly, my lord, this writ petition was not needed to be taken further. The increase was given, the students took the admission, and this writ petition was subsequently withdrawn. Subsequently, my lord, what had happened was, again, in 22, if my lord can have page 71. No. My lord, in 22, they were, because this was for 2021 session, my lord, literally. Because of COVID, it got a little late. 71, relevant is 74, my lord. This is writ petition number 88222. Order dated 22/2/22, my lord, I'll just have the facts, para 2, my lord. Petitioners herein all candidates belonging to so and so for the purpose of admission to postgraduate courses in so and so. The grievance raised is as per the 103rd Amendment of the Constitution of India. A quota for the economically weaker section was introduced. 10% of so and so is to be fitted across the unreserved as well as reserved quota. As the EWS quota encroaches upon the seats available to the unreserved so and so, there is a grievance that because of introduction of so and so, the entitlement of the reserved so and so classes otherwise would be adversely affected. Para 4 at page 75. In course of hearing in WPC 3007/2020, that is the first order. The Medical Council had agreed to the proposition that number of seats in postgraduate courses in medical colleges in Assam be approximately increased by 25%, so as to accommodate the EWS quota without otherwise disturbing the number of seats available for unreserved as well as reserved category prior to so and so. Now, para 6, my lord. The NMC, which is successor in interest of the erstwhile Medical Council of India, has filed an affidavit stating inter alia the number of seats that would be required to be increased for implementing so and so in the medical colleges for the year 2021, be it also done in the same manner as it was done for the admission to postgraduate medical colleges for the year 2021. Now, basing on this, my lord, same chart was prepared at page 76, my lord would find, which my lord would find even in that 3007. 76. Then, my lord, at page 77, para 9. The authorities in the Health and Family Welfare Department may act accordingly and increase the seats as indicated above. The requirement of increasing the seat be done before the next round of admission so that no inconvenience would be caused to the candidates. So, my lord, again, the next page, page 78. WPC, my lord, 6498/2022. This was for the year, my lord, 22-23. Relevant days, my lord, page 81. Order dated 39/22. Same, my lord, everything from that or judgment was taken over. And my lord may have page 83, para 7. In view of the stated stand of the NMC and noticing the similarities in the present case, the writ petition is disposed of by directing the authorities in the Health and Family Welfare Department to the Government of Assam to do the needful to increase the seats in postgraduate courses in medical colleges in Assam for the year 22-23 in the same manner it was done for the year 21-22, as extracted in the order dated so and so and so and so, which is also extracted herein below and made a part of this order. Accordingly, my lord, page 85, the direction was there. Now, my lord, we are in 23-24. And the only problem I am facing, my lord, page 101. My lord, this is the new modality they are trying to bring in. Centralized counseling, my lord, page 101, Annex N. My lord has got it. My lord, this is the centralized, my lord, counseling process that they are trying to bring in on 14/6/23. The relevant would be 102, my lord, clause 6. My lord, it says, no new seats will be taken up by MCC and added in already existing seat matrix once counseling starts. So, my lord, if this 25% increase, they had increased it last time. My lord said there were 100 seats last time. They made it 125. But now when they are trying to make it for this year, they have forgotten that 25. They are again coming back to 100. They'll give 10%, but they are not giving us that increase of 25%. So, my lord, if this is finalized, the counseling dates have not been finalized, it can be finalized any moment. If they do that without giving this increase, my lord, that would be, my lord, in violation of their own prescriptions. And because, my lord, those were given because we will be prejudiced. So, my lord, at this stage, my prayer would be, my lord, because if my lord requires the current position, lordship, I have made statements because I could not bring on record any document to that effect. But I've made statements, my lord, that the authorities have clearly told us that the 25% increase that was made last year will not be there. They will go back to the, my lord, minus 25% position and then proceed for the seat matrix thing, which would, my lord, prejudice us. So, my lord, my limited prayer is that my friend will, this appearing for the state, my lord, he might have some instruction, but be that as it may, my lord, my limited prayer before my lord is, because once the counseling starts, they will not add. So that would be beyond the proposition of anyone. My limited prayer is, my lord, if they are willing to give 10%, let them give that 10% after providing for that 25% increase. My lord, we'll leave it at that. Let them give that, like the years, my lord, from 1920 onwards, what they are doing, my lord. Let them give that 25% increase and thereafter proceed for the, my lord, 10% reservation thing. And the NMC in the meantime can submit its, my lord, instructions, whatever it's. So, my lord, both sides are protected. My lord.
So far as the state is concerned, my lord, here we will be supporting the petitioner. If that 51 seats is given to us by way of a protection, my lord, by this honorable court, then we can proceed.
NMC.
My NMC, my lord. And one more thing, my lord, for last 3 years, my lordship has seen the orders, my lord, that has been placed by the petitioner side. My lord, only, my lord, when the petitioners approach this honorable court, these 51 seats are given to us. And thereafter we proceed with the counseling, seats are filled up. But it has not been regularized till then. That's why, my lord, every year, my lord, they have to come. NMC
So that's
must,
why,
my
my
lord,
lord, they
regularize
deduct it
51.
every year. My lord.
Once it is regularized, my lord, then without that, my lord, approaching the honorable court, we can, my lord, fill up the seats. Otherwise, we are at the mercy of the NMC till date, my lord. And my lord, one more thing, counseling can be held anytime in July, my lord. They will notify and accordingly we'll have to go.
What we have heard, my lord, it will be before 15th, around about 14, 15th, my lord, this will start off.
May it please your lordship. Lordship, I appear on behalf of the NMC, my lord, the respondent number 5 in the instant matter. I've been served copy today, my lord. And what my learned senior friend has stated as regard to this scenario in the preceding years, my lord, that is a matter of record that has been happening, my lord. That once that issue was addressed in the session of 2019, that certain seats were increased. Then on the subsequent session, academic session, again, those seats were not available. Then we took the instructions and we were instructed that yes, the seats which were increased in the previous academic session would remain the same. They would not be again taken off. So that was the stand in the preceding 2 years, my lord. That is the last year and the year before that. So possibly, my lord, it would be probably similar instructions would come. I would just require a short period of time, my lord, to get the instructions.
Day after tomorrow?
Day after tomorrow is fine by me, my lord.
Yes, Nair?
But only the problem, my lord, I've been told, my lord, there won't be much quotes on that day, my lord.
Yes.
That's why.
Many.
Many are not there, my lord. That's what I was.
It's being an urgent matter. If it is
But my lord, can this, I have, what my friend is saying,
I
my
can
lord,
say
if there is anything contrary,
on
they-
top of the list,
lordship,
on top of the list. Yeah,
lordship. My lord will also not be here, my lord.
I'm not here.
My lord will then put it, because only thing, my lord, if
think,
lordship is otherwise pleased,
I think 4 or 5 judges. will-
7, my lord, I've been told. Anyway, my lord, that's before vacations. We would have otherwise had a holiday also. There was a move, but it did not fructify. My lord, only limited prayer. My lord will not pass a final order today. My lord will pass an interim direction. Let the matter be listed immediately after the vacation. Let them have their instructions, my lord. My lord only will say that the increase which was there last year, that should not be done away with.
No, he wants some instructions.
The instructions, my lord, pertaining Friday, my lord,
Friday we'll have it on the top of. the
my
list.
lord will do. My lord will do it, my lord. Let my friend have that instructions.
My lord, possibly the matter may be sorted once and for all, maybe day after tomorrow, possibly, my lord.
Lordship,
There's a
lordship.
possibility, my lord.
Lordship.
Mr. UK Ireland, senior counsel, assisted by Mr.
My lord, K. Pathak, my lord.
K. Pathak, learned counsel. On request made by Mr.
DK Boydda, my lord.
D.K. Winter Learned, standing counsel,
Standing counsel NMC, my lord.
National Medical Committee.
Commission, my lord.
Commission.
Respondent number 5 in the instant matter.
Public respond number 5. List the matter on 30 June. You enable him to list the matter on 30 June at the top of the list. You enable, list the matter on 30 June to enable her to receive instructions. The matter be listed at the top of the list.
Lordship.
Deeply obliged, my lord.
Much obliged. Top of the list.
13 of daily list and 41 of supplementary list.
My lord, that top of the list, my lord, may not be because the list is already out. My lord. It will come in the supplementary list. We'll make a prayer.
Okay, cancel that.
So the list is already out. my lord. Much obliged.
Lordship, this matter was last posted on 21st of this month. During course of hearing, it was noticed that some typological error in the page number 4 of my application. Accordingly, I have filed an IA to correct the typological error. This is just a serial number. Error occurred in the serial number 1, 2, thereafter it came 9.
1 minute. Where's your IA?
IA number 1548. The typological error occurred in the page number 4. And correction, and for correction the error that I have filed the IA, which is the IA number 1862.
1862 is it listed now?
This item number 41. Supplementary list.
Where's the letter? Yes.
Lordship, you just page number 4, 1, 2, thereafter it came 9, 10, and 11. That portion is to be corrected, Lordship. That serial number.
Okay, in the IA. Number 1862, item 41. But Mr. FZ Mazumdar and counsel for the petition applicants. Also heard Mr.
M. Ali, my lord.
M. Ali, Leonard Council, appearing for the,
For respondent number 1 and 2.
for the respondents 1 and 2. And Chisti, you appearing?
I am for the move to the in 1 and 2. I am for a state as per secondary department lordship.
Mr. Jesse, standing council appears for
Pro
the
forma.
secondary education department. Stop. By this application, the applicant is praying for correction of the post title in IA number, IA within bracket C, number 1548 of 2023. Filed in WBC number 8280 of 2022. For correction of the typographical error with regard to the serial of the respondents in IA 1548 of 2022. Stop. He submits that instead of the respondent's serial number being shown as instead of the respondent's serial number 1 to 9, 10, 11, and 12, the same may be read as 1, 2, 3, 4, and 4, 5, and 6. Stop. After hearing the legal counsel for the parties, the prayer for correction of the cost title with regard to the serial number of the respondents in IA number 1548 of 2023 is allowed. Stop. The registry is directed to do the needful. Stop. When shall we list it?
Lordship, should we acknowledge stay vacating application subject to your approval, Lordship?
No,
Because
this correction has to be done first by the registry.
Yes. Yes.
List list IA number so and so along with WBC number so and so on
on 17th or 18th, Lordship,
19th.
19th, Lordship.
Office won't take it.
14, treatment of parties.
Obliged, Lordship.
Please, your lordship. But in this case, my lord, some development has been occurred, my lord, so matter will be taken after vacation, my lord.
Yes.
May take after vacation.
On request made by the learned counsel for the parties, list the matter after the summer vacation.
Obliged.
38 of supplementary list. Motion.
Hello, this is the matter which had come up on Monday. Assam Open School, your lordship recalls, best of 5 subjects. We had got adjourned because the council for the higher secondary council was not there. In a similar matter, my lord, your lordship has this order. I passed an well, this 81, 82, if your lordship would recall, at page 81 is the impugned notification. This is advertisement is 11 February 2023. And this is pursuant thereto an order was passed changing the rules of the game. There is my lord, if I may read my lord. Whereas the Director of Elementary Education, Assam, my lord has page 81. My published advertisement for recruitment in regular vacant post of LP and UP school by the advertisement dated 11/2/23. So advertisement is a prior date. For 5
9320 vacancies of LP and UP teachers till the last date of application is 9/3/23. Whereas it has been found a large number of candidates have applied with betterment improvement mark sheet at the higher secondary level under the Assam State Open School for the set post against the advertisement. There is an improvement scheme under this Assam Open School system. Whereas it has come to the notice of the directorate that the Assam Higher Secondary Council has published one notification dated 14/3/22, wherein by point F and G, the council has made it clear that students applying for admission under improvement scheme may take admission only in the subject that have appeared in the qualifying examination, and for applying under the improvement scheme, the candidates may reappear in the same subjects only, and one chance will be given to regular learners. Whereas the Director of Elementary Education, in its earlier recruitment process, used to consider the best of 5 subjects from both the original HSSLC mark sheet and the betterment mark sheet. While doing so, English and one MIL, such as English, Assamese or Bengali, etc., were compulsorily kept as the core subjects due to lack of clarification as to the subject that a candidate can select in betterment improvement scheme. Therefore, considering all aspects, it has been decided that in the forthcoming physical document verification against the aforesaid advertisement, the best of subjects from both the mark sheet, original HSLC, and that of betterment scheme will be considered, but it will be only in case of subjects that are same with that of the original HSLC mark sheet of the candidate. Subjects that are not in the earlier qualifying examination, original HSLC, will not be considered, my lord. 2 submission, my lord. 1, the advertisement being of a prior day, the process has already begun, so you can't change the process. And if your lordship, second submission is, even if your lordship sees the notification which is relied upon in the subsequent page at 82, that is from academic session 22-23, and the petitioners before your lordship have already done under the old scheme. It is notified to all concerned institute under the Assam State Open School that online admission recruitment 21 will be open on or from 11th March 22. The last date of submission of HS level examination for filling up the online registration form for 21-22 and other information from the mentioned below. And if your lordship sees F and G is which is the new change brought about. The students, if your lordship in F, 3rd line, student applying for admission, lordship has that.
Yes.
Under the improvement scheme may take admission only in the subjects they have appeared in earlier in the qualifying examination. For appearing under the improvement scheme, candidates may reappear in the same subjects only. Now, if your lordship sees, so far as the petitioners are concerned at page 28, when they did this course, such condition was not there. Because this new stipulation came about in academic session 22-23. This at 28, so far as the petitioner one concerned, it is the open Assam State Open School. Now, this examination commenced on 31/10/22, so it is not academic session. 22 started only in March. So subjects, if your lordship sees, English, home science, painting, and data entry operation. Compare it with, your lordship will compare it with his higher secondary mark sheet in the following page at 29. The subjects are different. So when he gave the, under the Assam Open Schools, there was no restriction that it is restricted only to the subjects that you appeared in HSLC examination. So my lord, now from academic session 22-23, they wouldn't have allowed like this. Then it would have been restricted to what are the subjects at 29. Whatever you give in HSLC, you can improve in the improvement scheme. Now that is from 22-23 onward. But when these candidates gave, there was no such prescription. They were allowed to give other subjects. So the prevailing in the earlier recruitment, that's why your lordship would find that 81 in the middle paragraph, in the fourth paragraph, whereas BEE Assam in the earlier recruitment processes, lordship has that in the fourth paragraph in page 81, used to consider the best of 5 subjects from both original HSLC and the betterment scheme. While doing so, English and 1 MIL, that is such as English, Assamese, Bengali, were compulsorily kept as the core. So earlier recruitment process, they took the best of 5 of both the examinations, but English and 1 MIL is compulsory. So the best of English and MIL compulsory, the rest of the 3 subjects, you can take the best of HSLC or the improvement scheme. Now, because the condition is that you can only appear in the subjects where you appeared in the HSLC examination, so there can be the same subjects. So, so this condition, my lords, one, because the advertisement is dated 11/2/23, this notification is 28/23. One submission is that you can't change the rules of the game once the advertisement is issued. And second, even assuming this notification which they seek to rely is for people who has taken admission from academic session 22-23. Now, my lords, in a similar matter, my lord learned friend had appeared. I passed an order if your lordship has that, otherwise I can hand over, my lord. It is writ petition 2968. My lord has. It's another district. While issuing notice, so far as the interim is concerned, if your lordship just have the last paragraph, Miss Goswami, learned counsel for the petitioners, praised for an interim order. At this stage, Shri Kaushik, my learned friend, learned standing counsel for the department, submits that more vacancies are likely to come up with, which would be filled up in due course of time under the on those facts and circumstances. Though this court is not inclined to pass a blanket order of state, is observed in the event the petitioners make out a case for interference. Their cases will be required to be considered in the ensuing vacancies. If your lordship, I am praying for a similar order, my lord. It is another district, same, if your lordship sees, same notification was under challenge. The first
issue is same.
My issue is same. 28/2/23 was under challenge.
The only difference is in that petition, this order was passed before the selection was over. Now the selection list has been published. So the recruitment process
That is that the provisional merit list was put under
Yes.
challenge, now selected, but the
Are
vacancy.
some vacancies going to come up?
Yes, there are lots of vacancies, my lord. Even pursuant to the advertisement.
Yes, in case I'm able to satisfy your lordship that in the writ petition may warrant
There's no difficulty if your lordship
be
passes the same
allowed,
order.
then at that point my
But Mr. B.K. Goswami, learned senior counsel, assisted by MS J. Gogoi, learned counsel for the petitioners. Issue notice. Mr. P. Kaushik, learned standing counsel.
My lord, I am appearing for respond number 1, 2, 3. 1, 2, 3, my lord.
Learned standing counsel, higher education.
Elementary, my lord.
Elementary or higher?
Elementary, my lord.
Elementary education appears for respondents.
1, 2, and 3.
1 is higher education.
It's wrongly written as higher, my lord, probably. Because
Okay,
the
1,
advertisement is of
1, 2,
elementary.
and 3.
my lord.
How about 4?
4, my lord, it's
4.
higher secondary council.
4 and 6, my lord.
My friend appears.
Mr. D.K. Roy, learned counsel.
4, 5, and
appears
6.
for the respondent, learned standing counsel.
Yes, my
Standing counsel.
5.
Assam Higher Secondary Education Council appears
think
for
we-
the respondents 4 and 6, 5.
5,
Five and six.
He appears for 4 and 6, my lord. 5,
4 and 6.
Five.
Respondent 5.
I think, my lord, Central Government Council can appear. Is something.
Anybody appearing?
We'll take steps on 5.
Okay. Petitioner to take steps for service of notice on the respond number 5 by registered post AP within a period of 1 week from the date. Stop. List the matter after 4 weeks. Stop. You have cleared the cutoff marks.
No, if that, if the benefit, if the prescription of best of 5 of both the examination is taken without the restriction of safe charges, according to us, will meet the cutoff. Today, we are not in the select list, my lord. Because of this, we are out, my lord.
Mr. B. Kaushik, London Standing Council. Elementary education. Submits that more vacancies are likely to come up in the near future. Which would be filled up in due course of time. So in that we have implemented. This court is not passing any interim order at this stage. However, if the petitioners makes out the case for interference with regard to the grievance, their case would be considered in any ensuing vacancies. That must.
Deeply obliged. ma'am.
My
Deeply
friend can accept notice for respond of 5.
Okay, then cancel that line. MS.
Jay Sharma.
Jay Sharma Leonard, CGC. No.
Central Government Council.
CGC. So no need for Mr.
Deeply obliged. Deeply
Obliged.
Deeply.
40 of supplementary admission apart.
Nobody is doing it.
Forty. Four zero.
Higher education, we have. Yes, where's Mr. Saitya?
Lordship, I'm just calling DSK, Lordship. Just a minute. Lordship, may I take it after some time, Lordship.
At 2.
No, Lordship, he is there. I have to just inform you.
May it please your lordship. Today is my turn to give the response, lordship, of the petitioner's site's submission. So basically, what they are submitting is that they are outstayed without notice and by violation of certain provisions of law, according to them. I would like to place the case in the right perspective of the facts, which I have stated in my affidavit. If lordship is pleased to take up my affidavit filed by Dr. Urubjuti Chaudhary, lordship, he is the registrar of KK Handik State Open University. Have lordship got it?
Yes.
Paragraph 4. I would like to read out 4, 5, 6, 7, 12, and 16. This will make the whole case very clear.
Para 4.
Para 4, 5, 6, 7, 12, and 16.
Yes.
Paragraph 4. As regard to the statements made in paragraph 2 of the writ petition, the deponent humbly begs to state that an advertisement dated 14th October 2020 was published in Assam Tribune by the KK Hendik Open University, calling for applications for different posts, including one post of professor under Hiranyo Kumar Bhuya School of Science and Technology. In the said advertisement, applications were called for from the discipline of computer science and mathematics. That advertisement, Lordship will find at page 17, Annexure A. This is the advertisement. Applications are invited from Indian citizens for professor under Hiranyo Kumar Bhuya School of Science and Technology, one post. And next page, Lordship will kindly see page 18, serial number 4. Professor under so-and-so, one post. The applicant must have the following discipline: computer science and mathematics. Thereafter, they have issued their corrigendum, which I'd like to come to paragraph 3 once more. Subsequently, a corrigendum was issued in Assam Tribune News edition dated 27th October 2020, stating inter alia that qualification for the post of professor under Hiranyo Kumar Bhuya School of Science and Technology may be read as the applicant must be from any discipline of science and technology, which Lordship will find at page 20. Serial number 2, the qualification for the post of professor under so-and-so school may be read as applicant must be from any discipline of science and technology. So initially it was mathematics and computer science. Now they have opened it up. May I continue with paragraph 4, page 3. In the said recruitment process, the following candidates applied, namely Dharmaranjan Das, Jayanta Kumar Sharma, Ujjwal Sharma, and Dr. Jyoti Rekha Hendik. On assessment of the applications by the experts, 3 candidates, namely Dharmaranjan, Jayanta, and Jyoti Rekha, were shortlisted and called for interview, which was held on 22nd of December 2020. It is found that the candidature of Ujjwal Sharma was rejected on the ground of non-fulfillment of eligibility criteria. Even though Ujjwal Sharma had fulfilled the requisite criteria for the post, his candidature was rejected for reasons not specified. There was biasness from the very beginning. The said candidate had master's degree in computer applications and also MPhil and PhD. This school under the university, Lordship, has 2 departments on it. One is computer science and the other one is mathematics. And Jyoti Rekha Hendik is a chemistry professor of Dibrugarh University. And there is a design to bring her to Guwahati. That is the whole case. She is the wife of the, we have stated in our affidavit, wife of the VC of Guwahati University. And there is a nexus with the VC of KK Hendik University. That is why they designed it such a way that the wife of that VC of Guwahati University comes from Dibrugarh to serve in Guwahati. That is the whole case. I'll come without violating any norms. We have done it at the instance of the then Chancellor, the Governor of Assam. And on top of that, there is no such subject of this computer applications and mathematics in this institution. In spite of that, they appointed one chemistry professor, where that subject is not there.
No subject of,
Her subject was chemistry.
and in the institution, there's no subject of.
Mathematics and computer science. The existing post, computer science and mathematics.
No, you're saying in the institution,
Where
there's no subject of chemistry.
no
and-
subject of chemistry. Now may I continue? Accordingly, the interview was held on the date fixed and selection committee recommended only the name of Jyoti Rekha Hendik, opposite party, for being appointed as professor under Hiranyo Kumar Bhuya School of Science and Technology. Thereafter, paragraph 5, the deponent humbly begs to state that on being approved by the Board of Management in its meeting dated 23rd December 2020, Dr. Jyoti Rekha Hendik, the petitioner, was offered the post of professor in Hiranyo Chandra Bhuya School of Science and Technology, Bhait, later dated 24/12/2020, on provision basis for a term of 1 year in terms of KAH SOU Act 2005, the statutes and the rules of the university as amended from time to time. The appointment letter specifically mentioned about the terms of probation. Lordship will kindly come to that appointment order. At page 24. The 23rd meeting held, and on 24 December 2020, the appointment order was issued. May I read it? It was issued by the registrar to Jyoti Rekha, subject recruitment to the post of professor in so-and-so institution, your application and subsequent interview on 22nd December 2020. I am glad to inform you that you are selected for appointment to the post of professor in Hiranyo Chandra Bhuya School of Science and Technology under the general terms and conditions to be regulated by the KK Handic Open University Act 2005 as amended up to date. The statutes, ordinances, rules of the university in force from time to time and under the following terms and conditions: name, professor so-and-so, nature of post permanent, scale of pay so-and-so, initial salary as per SOU rules, probation, that is important. Subject to the provisions of the statutes, this appointment is made on probation for a period of 1 year from the date of joining. However, the appointing authority shall have the power to extend the period of probation. This offer of appointment may be withdrawn at any time during the probation period based on administrative reasons which will be binding on you. This last line is very important. This offer of appointment may be withdrawn at any time during the probation period based on administrative reasons which will be binding on you. So before 1 year, we can withdraw that on administrative reasons. So she knew this condition. She joined in the post, next page 5 again, Lordship. Paragraph page 5. She joined the said post on 1st January 2021 in Lien for 2 years from Dibrugarh University. She was working in as a regular professor. Page 5.
Page 5
Yes, Lordship.
of the writ petition.
Of the writ petition. Oh, sorry, of the affidavit.
Okay, okay.
Which Lordship is page 5. I was continuing.
Yes.
Then paragraph 6. So she joined on 1st January. So within 1 year, Lordship, we can withdraw her appointment also under the terms and conditions of appointment. Paragraph 6. The deponent begs to state that it is a fact that during the tenure of probation, the petitioner was entrusted with various internal affairs responsibility of the university for its smooth functioning. However, anything beyond the records may be treated to have been denied and disputed because she was working at basically the administrative side, because she does not have a subject of her expertise. Chemistry is not a subject. The subject which are available in this institution is mathematics and computer applications. Say paragraph 7. The deponent states that Hiranyo Chandra Bhuya School of Science and Technology has 2 disciplines, namely mathematics and computer science, which were duly approved and recognized by UGC for open and distance learning. So UGC have to give approval to the subject which we are teaching in our institution. In an earlier recruitment process initiated in the year 2019, applications were called from candidates of mathematics and computer science streams only. Surprisingly, in the advertisement under reference and under the leadership control of the then Vice Chancellor, Dr. Kondorpo Das, it was made open to the science stream when the said school had no other subjects in offering other than mathematics and computer science with due approval recognition from competent authority. It is found, pausing here for a moment, Lordship, there is another history of Kondorpo Das, the Vice Chancellor. He ran 23 subjects without approval, 23 courses without approval from UGC. He had only 10 courses approval. For that misdeed, he ran this from 2010 to 2017. And for that, the governor, or the same chancellor, took strict action and removed him from service, from the post of Vice Chancellor. It came before this honorable court, no court interfered. So this gentleman, Dr. Kondorpo, he is a VC. He had his whole track record where he was flouting all norms of administration as well as the other norms relating to education. So here their subject was not there. He recruited a person of chemistry. It is found that Sri Dr. Jyotirekha Hendik is of chemistry stream and the institution in question neither has any approval for the subject chemistry nor an approved course of BSc General till date. Be it stated herein that it was the chairman of the selection committee, the then Vice Chancellor Kondorpa Das, who conducted the entire process relating to the selection to the post of Professor of Hiranya Chandra Bhuya School of Science and Technology. Stating the aforesaid facts, a communication dated 10/9/2021 by the Honorable Governor of Assam, Chancellor of the University, from Governor's Secretariat was made to the Chief Secretary Assam with a prayer to take necessary actions in the aforesaid situation. In the said letter, it was mentioned that in spite of there being a decision in the meeting of Vice Chancellors of state universities of the state held on 18 December 2019, that recruitment of faculties have to be circulated through local Assamese-based Assamese and English newspapers as well as 4 national papers, yet the same was not followed in the instant case. Further, the shortlisting of the candidates was not done in terms of the UGC norms and ineligible candidates were called for interview by rejecting the eligible candidates, namely Ujjwal Sharma. He was highly qualified in that particular subject, which had the requisite API score as per UGC and open distance learning experience. The Honorable Governor was of the view that some vested interest was involved in not rejecting the ineligible candidates and selecting only the petitioner, that is Professor Jyotirekha Hendik, who is the wife of Pratap Chandra Hendik, Vice Chancellor of Guwahati University, and the same remains in the contention for the post before the selection committee. In the light of above facts and circumstances, the Education Higher Department of Government of Assam called for an explanation from the university, and on getting due response from the university and after deliberation, a letter dated 3/12/2021 from the Special Commissioner to the Government of Assam Education Department was communicated to the VC, KK Hendik University, asking them to take necessary actions as per statute of the KK Hendik Open University regarding anomalies in the recruitment of Jyotirekha Hendik. Further, anything beyond the records may be treated to have denied and disputed by the answering. So Annexer E, Lordship will kindly come to page. Annexer is at page 26. So Higher Education Department, Government of Assam, because the government cannot directly take action. It is under a different statute, autonomous body. So as it is a government institution, university lordship, government has requested the authorities of the university to take appropriate action. So the Special Commissioner to the Government of Assam Education Department wrote to the VC, KK Hendik Open University regarding recruitment to the post of professor in so-and-so. Reference letters, certain letters were referred to. One is from the Governor's Secretariat. 10/9, reference Lordship number 1, GSA. That is Governor's Secretariat. And other one is from the university. With reference to the subject cited above, I am directed to request you to kindly take necessary actions as per the statute of the KK Hendik Open University regarding anomalies in recruitment in respect of Dr. Jyotirekha Hendik as professor in Hiranya Chandra Bhuya School of Science and Technology, KK. This has the approval of the Chief Minister. So it was sent to it, and copy was also marked to the PS of the Governor House. And thereafter, paragraph 8, Lordship, I would like to read page 8. The deponent begs to state that the Board of Management of KK Hendik University, in its 64th meeting held on 8/12/2021, after deliberations resolved to comply with the directives from the Government of Assam, by letter dated 3/12/2021, which I have just placed, and His Excellency is the Governor of Assam and Chancellor of the University. However, anything beyond the record is not. So the Annexer F, page 27. The meeting of the Board of Management of the University, page 27. All the members, including the VC, was present, and other members of that board are all present, including the register, full board. Item number 1. Directives given by the Special Commissioner to the Government of Assam Higher Education Department. The Board of Management was apprised about the letter received from the Special Commissioner, Government of Assam, dated 3/12/2021 regarding recruitment to the post of professor in Hiranya Chandra Bhuya School of Science and Technology, KK Handik Open University. The same had a reference of an earlier communication to the Secretary to the Government of Assam, dated 8/10/2021, that enclosed a copy of the letter dated so and so from the Honorable Governor of Assam and Chancellor of the University, requesting immediate necessary actions for termination of the appointment of Jyoti Rekha Handik as professor in Hiranya Chandra Bhuya School of Science and Technology. The matter was placed before the Board of Management for information and approval for compliance. After threadbare discussion, the board on principle agreed to comply with the directives of the Government of Assam and the Honorable Chancellor of the University. Resolution. Resolved that the directives of the Honorable Chancellor as per communication received from the Government of Assam letter dated 3/12/2021 be complied with. The board has further resolved that legal clarity be ensured by the university on the language and content of the letter to be issued to Professor Jyoti Rekha Handik of so and so. So this was the decision of the board. Thereafter, 9. They have challenged in this instant case. In the present case, they have challenged. In the present case, they have challenged the order dated 16/3/2022. At page 112.
112.
Annexure J 112, Lordship.
Yes.
16/3/2022. May I read it, Lordship? In pursuance of the decision of the 64th meeting of the Board of Management held on 8 December 2021, read with the provisions of the clause B, Roman 6 and Roman 7 under chapter 4 of the first statute of the university and the terms and conditions of appointment. This is very important, terms and conditions of appointment, that we can withdraw it within 1 year. The services of Jyoti Rekha Handik on probation as professor in Hiranya Chandra Bhuya School of Science and Technology is withdrawn with immediate effect because of administrative reasons. We have said for administrative reasons we can withdraw. And rejection of UGC to provide recognition to BSc General Program by letter dated 12/10/2021 in Hiranya Chandra Bhuya School of Science and Technology. This was approved with the approval of, this was issued with the approval of the Vice Chancellor. So this was the withdrawal letter. Now, Lordship, the query will come from this Honorable Court, whether we have done it within 1 year or not. Because it was, she joined on 1/1/2021 for January. And this was in March 2022. So there is a lapse of 2 months or maybe more than that. For that, my answer is, Lordship, page of my affidavit, page 29. In fact, there are another case which has to be heard actually together with this, because in the other case, certain orders were passed. Now, our present case is, Lordship, 2017 of 2022. The other case is 6604 of 2021. There are certain orders which they have challenged, and what was the order of the Honorable Court? I would like to place. That will give the complete picture. Page 30. It starts from page 29, the case number, Lordship, may make a mark. WPC 6604 of 2021. Page 30, Hertz, K. N. Chaudhary, so learned senior counsel, etc. the petitioner projects that she was appointed as professor under Hiranya Chandra Bhuya School of Science and Technology under the general terms and conditions to be regulated by KK Handig Open University Act 2005 on probation for a period of 1 year via communication dated 24/12/2020. It was submitted at the fag end of the probation period by communication dated 3/12/2021. Respondent number 2 asks the VC of KK Handig University respondent to take action as per statute of the university on the ground that there was anomalies in the recruitment process. So that higher education principal commissioner lordship wrote to the VC. That letter I have placed on of 3rd December 2021. They have challenged that. Learned Senior Counsel appearing for the petitioner submits that as per the impugned letter dated 3/12/2021, there is an allegation against the petitioner regarding anomalies, and accordingly he submits that there is a strong apprehension that the authorities may terminate the services of the petitioner as professor. It is submitted that termination of the petitioner from her employment, if done, would be stigmatic. Hence, the learned senior counsel for the petitioner prays for interim protection of the petitioner. The learned standing counsel appears for has opposed the interim protection, etc., etc. Issue notice, last paragraph. As regard the prayer of interim, this court is inclined to provide that while there is no bar for the respondent authorities to take action against the petitioner as per the statute, but no final order shall be passed until further orders from this court. The court allowed us to proceed, but don't issue the final order. So from 3rd December, we started because the 8th meeting was held by the board. Board also approved 8 December that we are going to comply with the direction given by the Higher Education Department, Government of Assam, by letter dated 3rd of December. So 8th of December, the board took the resolution that we are going ahead. In the meantime, this order was passed on 8/12. Lordship will kindly come to page 30. The day when the board took that decision, on the basis of the 3rd December, they lodged the brief petition, and on 8th, they could get this interim order. That was, and leased the matter on 24th of January. So next date, fixed by the learned single judge on that day, on 8th of December, that fixed the matter on 24th January. So this 1 year period will be over on 1st of January 2022. Immediately we filed vacating petition. Lordship will kindly come to page 33. Why this case is very important, the other case also to be heard together. This will give the clear picture. It was ordered on 15/3/2022. We issued the impugned order. After we got the order vacated. Yes. Yes. If Lordship just reminds the earlier page 112, the order was issued on 16/3. On 15/3, we could get the vacating order. I'd like to place this vacating order. Most of the facts were recorded in this order. The instant interlocutory application has been filed for vacation of the interim order dated 8/12/2021, passed by this court in the connecting writ petition number 6604 of 2021. There are two applicants in this IA who are added as respondent number 4 and 5 in the writ petition, namely KK Handig Open University and its vice chancellor. Before going into the controversy, which requires a determination to come to a finding as to whether the interim order dated 8/12/2021 is liable to be vacated or not, the basic facts of the case may be put on record in the following manner. The opposite party number 1 writ petitioner was serving as professor in the Department of Chemistry, Dibrugarh University, for around 27 years of teaching experience. She came to know that Hiranya Chandra Bhuya School of Science and Technology under KK University was conducting a recruitment process for 4 number of posts in the category of professor. The writ petitioner, considering herself to be eligible and qualified, and had applied for the said post of professor and was selected, appointed for the same post by letter dated 24 December 2020. The petitioner claims to have discharged her duties without any blemish and was entrusted with various responsibilities. The cause of action for filing the writ petition is communication dated 3/12/2021 issued by the Education Department addressing the Vice Chancellor of KK and the Open University, requesting to take necessary actions as per the statute with regard to the anomalies in recruitment in respect of the writ petitioner. The writ petitioner contends that the impugned action is not in conformity with the settled law as well as the provision of KK Hendik Open University Act 2005 and the statute's rules framed thereunder. The writ petitioner further alleges violation of the Constitution and other legal rights. This court, after hearing the learned counsel for the writ petitioner by order dated 8/12/2021, while issuing notice, had given interim protection to the effect that while there is no bar for the respondent authorities to take action against the writ petitioners as per the statute, but no final order be passed until further orders. It is in this interim order in respect of which the present IA has been filed. I have heard so and so, assisted by so and so, for the applicant whereas contesting oppositions, so and so K.N. Chaudhary, learned senior counsel, and B.J. Das, then learned counsel. Sri Saikia so and so, before touching the merit of the case, has however raised a preliminary objection on the maintainability of the writ petition itself. By drawing the attention of the court to the impugned order, namely the communication dated 3/12/2021, it is submitted that by the aforesaid communication, only action as per statute was directed to be taken, and in absence of any such action being taken, the writ petition is premature. As regard to the merit of the case, the learned so and so submits that projection made by the writ petitioner based upon which the interim order has been passed is wholly incorrect, wherein many relevant facts had not been highlighted. The most important fact, which is conveniently not highlighted, is that the recruitment is for the post of professor in the subject of chemistry, and in the present controversy, aforesaid fact of the subject in question is of crucial importance. While the said point would have dealt with by this court subsequently, the other important points is that the recruitment was with the condition that the appointment was made on promotion. This should be probation for a period of 1 year, which may be withdrawn at any time during the probation period. In this connection, reference has been made to the appointment order dated 24 December 2020, which has been annexed as Annexure D to the IA. The learned AG submits that for the period from 2010 to 2017, 8 number of courses were permitted for KK Hendik. However, the said ceiling of 8 number of courses was not maintained, and 15 other subjects were introduced without any approval of the UGC. It is further submitted that based upon the impugned letter dated 3/12/2021, an emergent meeting 64th meeting of the Board of Management of KK Hendik University was held, in which there was a threadbare discussion regarding the issue. The board had come to a conscious finding that the appointment of the writ petitioner was required to be terminated, and the said view was also approved by the Honorable Chancellor. It is submitted that there was no grievance against the writ petitioner so far as her qualification and eligibility is concerned, and only grievance is that her appointment was made against the non-existing post. Par contra, Sri K.N. Chaudhary, learned senior counsel for the opposite party, writ petitioner submits that recruitment was done by following the due process of law. The impugned action is not only unreasonable and illegal, but also lacks jurisdiction. By vehemently criticizing the impugned communication dated 3/12/2021, it is submitted that the Special Secretary of the Government of Assam Education Department does not have the power or jurisdiction to issue such letter to the BC. The KK Hendik University, being an autonomous body created by a statute and having its own hierarchy, the impugned communication dated 3rd December could not have been issued, and therefore it is submitted that no action whatsoever is liable to be taken on the basis of the said letter. To prima facie demonstrate that the activities of the writ petitioner, attention has been drawn to various documents annexed to the writ petition to show that different kind of activities done by the writ petitioner and the recommendations made by the authorities. He submits that numerous special responsibilities were entrusted upon the petitioner, which she had successfully discharged. By order dated 4/1/2021, the writ petitioner was also nominated as director of the institute as well as another institute, namely Guru Prasad Das School of Vocational Training, by an office order dated 12/1/2021. The writ petitioner was inducted as member of the steering committee of the KK Hendrick University and thereafter member of the library advisory committee. But she was not engaged in any teaching because chemistry is her forte and that subject is not available. So she was giving all these administrative works, which they have highlighted in the writ petition. By drawing the attention of this court to the various expert committee interface meetings to the program, namely Bachelor of Science combination of 3 subjects is not recommended. The remarks accompanying by the same has been stated as the SLM not ready. The learned senior counsel for the opposite party accordingly submits that nothing has been said regarding the requirement of faculty members, and it is only because of the fact that the self-learning materials were not ready and the program was not recommended. Sri Chaudhary submits the services of the petitioner could be very well utilized for preparation of SLM. This is their suggestion that she can be used for that particular activity, SLM. That means self-learning materials. Dealing with this aspect of stigma attached to the impugned letter, Sri Chaudhary Learned Senior Counsel has submitted that though the appointment was a conditional one with a probationary period of 1 year, any action taken for terminating the services prior to the expiry of 1 year would definitely be stigmatic. He submits that a bare look of the impugned communication dated 3/12/2021 would demonstrate that there were certain allegations against the writ petitioner for which impugned order was issued. Distinguishing the concept of termination simpliciter on expiry of the probation period and termination before the completion of the period, that too with allegations, it is argued that in the latter situation, the rigors of law, including affording of adequate notice and opportunity, have to be followed, which admitted has not been done. In support, the following judgments were cited. Now coming to paragraph 15, what is our step? Rejoining his submission, so-and-so submits that the point regarding lack of jurisdiction is not liable for consideration. There is no doubt that though the KK Hendrick University is an autonomous body, it is a state university created by the statute. The chancellor of the university is the governor of the state, and the majority of the fund is made by the state government. Section 39 of the KK Hendrick University Act 2009 stipulates that every statute, ordinance, or regulations made under this act shall be laid before the state legislative assembly for approval. In that view of the matter, the argument made on behalf of the writ petitioner that the impugned letter has been issued by an authority without jurisdiction cannot be sustained. He further submitted that no action as such has been taken by the impugned letter and the direction is only to take necessary action as per statute. The learned AG also draws the attention of this court to the minutes of the meeting held on 8 December 2021, from which it appears that the Board of Management has agreed to comply with the directives of the Government of Assam and the Honorable Chancellor of KK Hendrick. So it is not because of the state government's direction there. They have taken that call. They have applied their statute and they have also complied with the request made by the Chancellor of the university, the head of the institution. The board is the Chancellor is at the apex level, the highest person in the hierarchy. As regard the arguments made that the services of the petitioner can be rendered for preparation of SLM, the learned AG by referring to the notification dated 4/9/2020 of the UGC, published in the Gazette of India, more specifically Regulation 3B2, thereof has submitted that the said provision stipulates that at least 60% of the SLM are to be developed by in-house faculty. However, in the instant case, without the subject being approved, that is chemistry, the writ petitioner would not come within the meaning of in-house faculty. Their application for chemistry was rejected long time back. Then we are giving some just. It is submitted that the writ had come on Lian from Dibrugarh University, where she was getting a salary of 2.4 lakhs per month approximately, wherein in the present assignment, the monthly salary was 1.77 lakhs, and therefore there is no question of suffering financial prejudice. In support of his submission, so-and-so, this judgment was cited. In this case, the finding of the High Court was interfering with an order of termination was reversed, and the said termination was stated to be administrative reasons. This court has given anxious considerations of the rival submissions. The materials on record are also carefully examined. This court, however, makes it clear that since the present consideration is at the interim stage, while deciding an application for modification of an order, the reasons to be recorded are to be deemed to be as tentative in nature so that no prejudice is caused to either of the parties. Firstly, the objection regarding the writ petition being premature has to be examined. Though it is correct that the impugned order dated 3/12/2021 has only directed for taking appropriate action as per statute, the same direction would definitely fall within the meaning of qui timate action. The Honorable Supreme Court, in well-known case of Kihoto Holohan, has clearly laid down that in such a case, qui timate action, the High Court exercising the would be empowered to entertain the petition and pass appropriate order. One may also gainfully refer to case of so and so. We are skipping all this. Paragraph 22. In the consideration of this court, what is of crucial importance is the reason behind the contemplated action. That means releasing her during her probation. Admittedly, chemistry is not a subject approved by the UGC for the KK Handic Open University, and therefore the very process of recruitment of the writ petitioner for a subject which is not existing is not only erroneous but wholly illegal. This is a very clear-cut finding, Lord. That appointment was illegal because there is no such subject in that institution. If I don't have a car, Lordship, how can I have a driver? So precisely that is the reason why the Honorable Court held that the whole appointment recruitment of a chemistry professor for the post of mathematics or for computer applications is illegal. While the issue of such initiation of recruitment is not an issue before this court to be answered, the action of the KK Handic Open University in making recruitment for non-existing subject at the cost of public exchequer would perhaps require serious introspection and also inquiry. This court is unable to accept to the submission made that the services of the writ petitioner could be utilized for preparing of SLM. When the writ petitioner does not meet the basic requirement of being a duly inducted teaching faculty, such submission is absolutely liable to be rejected. This is a very strong finding of the Honorable Court, Lordship. So that means the appointment was illegal. Paragraph 23. It is, however, required to be clarified by this court that the aforesaid observation regarding illegal recruitment is not against the writ petitioner, though she is the beneficiary of such illegality. This is because of the fact that no fault can be attributed to a candidate who responds to a notice for public recruitment. Moreover, it is not because of any fault, shortcoming, misconduct on the part of the writ petitioner, which appears to be the reason behind the impugned notice dated 3/12/2021, but because of the sheer administrative reasons, namely recruitment made for a subject without such subject being approved by the UGC. This court is also conscious of the fact that the order of appointment of the writ petitioner was dated 24 December 2021, and she had joined on 1/1/2021, as revealed in paragraph 3 of the writ petition. In that view of the matter, the period of probation was otherwise come to an end, and in view of the fact that there was no discernible materials to impute any misconduct on the part of the writ petitioner, the discontinuation can very well be deemed to as termination simpliciter on expiry of the period of probation due to administrative reason. Under the aforesaid circumstance, this court of the view that the interim order dated 8/12/2021, by which an embargo was imposed regarding passing of the final orders pursuant to the impugned notice dated 3/12/2021, is liable to be vacated, and accordingly the same stands vacated. It is, however, made clear that any action would be subject to final outcome of the writ petition. So that is why, Lordship, both the writ petitions may be heard together. The other day, this was the submission made by my colleague, but the other side opposed that this is a separate, the other one. Both are interconnected. In that view of the matter, my humble submission, because certain documents are part of those that writ petition. The overall picture is very clear. That there was no subject of chemistry. Today also, there is no subject of chemistry. We have directly found that somebody was at the helm of affairs who was responsible for all this misdeed. While not having a subject, he recruited. And that gentleman is out of the university for various misdeeds. running courses, 13 or 15 number of courses without having UGC. He has put 55,000 students' life into jeopardy. They all got the diplomas and degrees from 2010 to 2017 by paying about 39 crores rupees. Those courses are not recognized by UGC, and with those subjects, with those diplomas, these boys and girls will be facing and are facing huge difficulties in getting job now, because these are all unrecognized courses. And same gentleman is responsible just to, he have to please somebody from his own parent university. He came to KK Handik University, this Kondorpa Das. He was a person of Guwahati University. He came here for 3 years. But before expiry of 3 years, he was ousted because of his misdeed. Not because he was more than 3 years or 6. Finally, he was, before his tenure was over, he was terminated. It's a very rare case that vice chancellor of universities get terminated. One gentleman is this gentleman, Kondorpa Das. The other one is Ranjit Tamuli of Dibrugarh University. And all these misdeeds were found out by the then chancellor of both the universities, the then governor. So my case is very clear, Lordship, that there was no subject. The appointment order very categorically stipulates that within the 1 year period, because of administrative reasons, we can terminate or we can withdraw the appointment. If this is the So my humble submission, Lordship may keep this matter as part heard, and further hearing may be directed along with the other repetition at this stage. I would like to, I have further submissions to make, but with the help of certain documents which are part of the repetition, which is not listed before this honorable court.
Lordship, if I may, Lordship, the other writ petition was with subject to that particular letter given. The particular letter dated 3/12/2021, where they decided. But the writ petition before your Lordship is a matter where the termination notice has already been listed, has already been given to her. So on basis of the Lordship, the other writ petition is infructuous, your Lordship. Because
Yes,
that is
what
no,
is
no,
it?
no matter a subject matter of challenge, Lordship.
Other cases like this,
Termination of-
Lordship. Suppose Lordship interferes with 16.3's disengagement letter. 312 will still be there.
Lordship, but this particular termination
The
notice,
core is that letter. The core letter is that,
the letter is
Huh?
before your Lordship in form of an affidavit, Lordship.
but that is not under challenge here. It's a part of the record.
So
Suppose Lordship decides that 16.3 was bad in law. That will remain. 8 December's board's meetings resolution is also will survive.
Lordship, if I may, Lordship, all the particular dates in the meeting.
I have no difficulty to complete my arguments.
Learned AGS submitted, Lordship. All those matters are part of the record, either in form of a writ petition or the affidavit that the state has filed, the university has filed, your Lordship. And second, Lordship, the writ petition is infructuous, Lordship. That subject matter under challenge does not exist as of date, Lordship. The subject matter is infructuous.
Let them withdraw it, then Lordship, fine. If
Lordship
they
will
withdraw
withdraw
that
it,
other petition, I have no difficulty in
Lordship,
continuing my argument.
I'll make a mention on Friday, Lordship, for withdrawal right after vacation, your Lordship. We'll withdraw the writ petition.
If they withdraw, I'll be more than happy.
Because that subject matter does not exist. That's not a live issue anymore, Lordship. What is live is the termination notice, which is under challenge in this writ petition.
Okay. Should we take up this after withdrawal or before?
Yes, Lordship. If they withdraw, because if they do not withdraw on Friday, suppose Lordship decides that this goes, then they will again come back.
Withdraw.
Because
Withdraw, Lordship.
I have lot of papers which have to be relied from that document also. Whatever the learned single judge also say,
Those documents are not in this writ petition?
not all, Lordship. Now, very important, the learned single judge said the views are tentative in nature.
views are tentative in nature. If their writ petition is withdrawn, then this interim order will merge with that order. That is why my submission of both the writ petition may be heard together.
Lordship, the interim
And that
order-
that order by which the earlier interim order was vacated, it was not put to challenge before the division bench.
Lordship, because the interim order was not put to challenge, hence the termination notice, Lordship. So, Lordship, there's no live issue as of and on the other writ petition, Lordship.
Then what should we do? Friday, this court will not be sitting.
Lordship.
Let it come on the reopening day or maybe 18th.
Lordship, if I may, I'll come back at 2, Your Lordship. I'll take instructions from my senior Lordship regarding what to do. Lordship, I'll come back at 2, I'll make a mention, Lordship.
Both are interconnected. The issues are interconnected.
Are you available at 2 o'clock?
I'm available, Lordship.
We'll come back at 2, Your Lordship.
Okay, we'll take up at 2.
Take care.
Lordship. Deeply.
Sixteen of daily late admission. Sixteen.
Lordship. As per last report dated, the department has to take an instruction as my year select law.
Yes, where's Kaushik? Elementary,
Lemon.
Furkan, are you here? Are you in this case?
Yes, my lord.
What are your instructions?
Matter may be taken after vacation.
Lordship, which is long pending matter, Lordship, and petitioner has completed his DLED course on Lordship 16/11/19, and since then his arrear salary is pending 16/11/19 to 28 to 21. Thereafter, he is getting regular salary, Lordship. So in that period, maybe order to given me, Lordship. There is a letter, Lordship, from Block Elementary Education Officer to Director, Lordship. This is the letter.
Yes, any instructions, Furkan?
Not yet, my lord. We have not received instruction, so after vacation, any matter may be taken up.
You are Mr.
DF Ahmed.
Heard Mr. D.F. Raman, learned counsel for the petition. On request made by N. Furkan, learned standing counsel, Elementary Education Department. list the matter to the summer vacation to enable her to receive instructions in terms of the order that it's 6/6/2022.
Fixed date may be given, Lord,
No. I'm not.
after vacation, Lord.
After vacation.
Date of 19, Lord.
Not the-
May it please your lordships. My lord, this petitioner, he could. One item,
70.
may it please your lordships.
Mm.
The petitioner before your lordships had challenged the order dated 5/1/2021 lordships. Page 17, annexure 5 lordships. Is the
Page?
respondent number
Page?
page 17,
Mm.
annexure 5.
Mm.
He is the respondent number 3 lordships in the read petition.
Mm.
Lordships, my name appeared at serial number 2 lordships in the inspection report. Lordship inspection report, that is page 9 lordships. My name is Prasanna Patar lordships.
Mm.
And respondent number 3, his name
Where's
Yes.
your name, serial number?
B lordships, page 9. A is Parikshit Das, headmaster. Next is mine lordships, Prasanna Patar. I am Prasanna Patar lordships. And this serial number 5E the lordships, Sri Jatin Chandra Nath. Jatin Chandra Nath, he was appointed in 1997, whereas lordships, I was appointed in 1994 lordships. And also lordships, this is the verification report lordships. Now lordships, the sub-inspector of school also submitted the report lordships. In the report also lordships, my name appeared at 2 lordships. Page 13, it is in vernacular, Kho Prasanna Patar and Ungo Jatin Chandra Nath lordships. Now lordship, this respondent number 3 is illegally appointed lordships, and accordingly lordships, I have approached before His Honorable Court challenging his appointment order and issuance of direction to the respondent authorities so that I may please be appointed in his place, lordships. This is the grievance I have.
Districts.
Lordship
Scrutiny,
district Borigaon lordship,
district scrutiny committee recommended to matter.
lordships.
Sukan,
My lord.
did the district scrutiny committee recommended the case of the
My
petitioner?
lord, we have not received any instruction. my lord. Father district.
This is a case of, this is a case of provincialization under the Act of 2017.
Yes, my lord, and my lord, district committee headed by the deputy commissioner.
Hmm.
So government will
Who appeals?
Ensure
Otherwise,
that-
it is a case of referring it back to the appellate forum.
it's not.
The only thing is,
Yes, my lord,
he has not come with all the details.
yes.
Has the district scrutiny committee considered your matter or not?
Lordship, regarding this, I have to obtain the instruction, Lord.
That is the issue.
Yes.
The inspector of schools has met his report.
Lordship, page 9.
That's fine. After the district scrutiny committee is supposed to consider your matter for provincialization. I don't know whether that has been done. But it appears district scrutiny committee has made its recommendation because the state level scrutiny committee has already passed the order. The only issue is whether district scrutiny committee recommended your case or did not recommend your case. These are the two, this is the only issue. You have not come with the instructions. District scrutiny committee is headed by the deputy commissioner,
Right.
isn't it? Who appears for the state?
The name of the petitioner was not recommended by the district scrutiny committee, Lordship, Morigaon. That is the instruction that we have received. I have seen it, Lordship. So if CC will file affidavit, Lordship, if required. That is the instruction we received. His name is not recommended by the DSC, Morigaon.
Not recommended.
Not
When was it held?
That date is not given, Lordship. Only that instruction has come. When that it was held, that was not given.
Because now see, there's two issues involved now. District scrutiny committee did not recommend.
Yes.
So on the basis of the recommendation made by the district scrutiny committee, the state scrutiny committee recommended the case of the respondent number 3.
Yes.
Now if he has to file an appeal
Before the SLC.
SLC has already recommended to respond 3.
But his case was not recommended by the DLC. So his grievance is against the DLC. DSC.
His grievance is that he is senior to the respondent number 3. You file your affidavit.
Yes, let her file affidavit.
But Mr.
It will.
R. Sharma, Legal Counsel. MS and Fukan, standing counsel. Elementary.
My lord.
Lordship.
Space for 3 weeks time to file contract. There is allowed. List of 2 weeks.
Hello.
18.
Lordship, here I have received my instruction today itself. I will file the affidavit within this vacation, but let it come immediately after vacation.
Lordship, this petitioner, he has been working as junior assistant, 1996, not even a single promotion to him. He's having all the
Then
qualifications.
let him file his affidavit. Make sure you file.
Yes, I have received it morning. Yes, I am sure. I'll file it.
Heard MSB Boyan and the senior counsel assisted by MS.
M. Chakravarti.
Chakravarti, legal counsel for petitioner. Mr. SMT Christie, legal standing counsel.
For secondary education, Lordship.
Secondary education submits that he has received instructions and prays for 2 weeks time to file counter affidavit. Praise a lot. Is the matter
After vacation.
up to December.
19.
19 also same, Lordship. I have received, I will file my affidavit, Lordship. I have already asked my colleague to prepare it, Lordship, both the affidavit, it will be filed
My lord,
immediately.
under the similar circumstances, my lord, your lordship, my lord, they provided the petitioner to file representation before the government, my lord.
Okay, yes, received it.
No.
Then
Yes, my instruction is that, Lordship, the state level scrutiny committee could not consider the case of the petitioner for the consideration of his service due to non-fulfillment of conditions laid down in the Act of 2017. This is the instruction. So we are filing affidavit, Lordship, let it come after immediately after application.
30 Barbuyan and counsel. for the petition. Stop. Mr. SMT Christie, legal standing counsel.
Second education, Lordship.
Yes, received instruction. And prays for 2 weeks time to file contract. Praise a lot. 1 minute time, 2 weeks. Is the matter after 2 weeks?
My lord, kindly, my lord, any date?
No, I'm not fixing dates.
It will come.
20.
Apply.
Your Lordship, this matter has come up for the first time since issuance of notice on 7/10/2021. Here, I'd like to seek some time to seek instructions in this matter, Your Lordship. I have not yet received any instructions.
Lordship, this is a 21 matter, my lord. In fact, my lord, our prayer is very simple, my lord. In the interference of Honorable Supreme Court during COVID period, the awarding of mark in respect of class 12 under CBSE was framed, my lord. As per the order of the Honorable Supreme Court, CBSE notified how to calculate the matter numbers in final examination in class 12. But in this case, the petitioner's daughter appeared. The number was awarded to the petitioner's daughter. It was not as per the notification issued by the CBSE pursuant to the order of the Supreme Court. This is my case.
Okay. How much time do you require?
Your
It's
3
coming
weeks
up
time.
for the first time after notice.
That's
But
what,
CBSE already appeared earlier occasion, my lord.
3 weeks, Your Lordship.
You are appealing for?
I am appealing for respondent numbers 1, 2, and 3.
Okay. But MS.
Shibora.
P. Bora, then the council. Mr.
D. Bora,
D. Bora, then the standing council CBSE.
on behalf of Mrs. R. Bora, standing counsel CBSE.
You're not the standing council.
I am not a standing counsel.
Mr. D. Bora, then the council appearing on behalf of MS R. Bora. Then the standing council CBSE. Prays for 2 weeks time to receive instructions. Praise allowed
Immediately after vacation, my lord.
after 2 weeks.
Obliged, Your Lordship.
21.
Please, Lord. I'm challenging the impugned appointment order at which page 32, Lordship. This is the post of state officer, Lord. Now, Lordship, may I take your Lordship to the page 28? This is the first advertisement for the post of state officer, Lord.
1 minute.
Qualification and experience, Lordship, will find essential qualification. Master of Business Administration with specialization in human resource management, having at least 55% of mark or its equivalent grade two in the UGC 7-point scale. Preference shall be given to the candidates having LLB degree. Acute knowledge of computer application. Experience,
You are for which post?
Lordship, in page 20.
Page
20. 20.
20.
This is the first advertisement.
May it please your honor, may it please your lordship, PJ Shoikia, the learning standing council of university, he has gone to home due to some personal difficulties. So kindly granted some time.
Lordship, I am appealing for respondent number 3, private respondent. We will file affidavit in opposition in.
It is a cases of 2021 and now we are in 2023. They have not filed the affidavit. It's quite
It's coming up for the first time after notice.
Yes, Lord.
Because of
So, we
COVID-19.
will file, Lord.
After vacation.
Heard Mr. R. Dhar, then the council for the petition. So, on request made on behalf of Mr.
A. Said.
A.
Said.
No, you are requesting on behalf of
PJ Shoikia.
PJ Cycle and its standing council.
PJ Fukan, Lordship.
PJ Fukun,
Then a standing council, Guwahati University. List
Guwahati
matter
University.
After the summer vacation.
And I am for respondent number 3, Lordship.
Mr.
MJ Gogoi.
Then council appears for respond.
Always.
Master.
22.
May I please, Lordship, here in this case, my lord, the issue is that my name has been recommended by the district scrutiny committee for provincial license, my lord. For the subject Assamese, my lord. Thereafter, my lord, the page, my lord, 39, my lord. Impugned order, my lord. Where it is found that, my lord, my name is not reflected in the DICE, my lord. DICE data, therefore, my lord, my provincial license was rejected, my lord. Here, my lord, this issue has already been dealt with by this honorable court, my lord. I have submitted this, my lord, order, my lord. Already settled, my lord, this issue, my lord. Even, my lord, in definition of 2017, my lord, 3(2)Z, my lord, which define the Venture Junior College. And that definition, there is no mention about the dice, my lord. Therefore, my lord, keeping it pending, my lord, it will be my lord.
Yeah, Catania,
It's otherwise, well, dice is not a requirement under the act, my lord. But thing is that we just to verify whether the person is working, we just refer the dice, my lord. Whether he was working or not, that to a certain that, my lord, we
That
insist
observation
for the
is there,
dice,
my lord.
dice, my lord.
There.
Otherwise, under the act, my lord, there is no requirement of dice. But there is no other way to verify, my lord. That's why we call for the dice from the SSA, my lord.
And my lord, in the judgment, it is observation is already there, my lord. In the
Right.
judgment, I have referred. My page, my lord, 30, para 19, my lord. Which says after verification, my lord, it will be, my lord, considered. Page 30, para 19, my lord.
you were in the Venture High School.
Yes, my lord, Venture Junior College, my lord. It will come under Venture High Secondary.
Venture Junior College.
Yes, my lord, Venture Junior College. Definition at 2Z, my lord, of the 2017 Act, my lord. There also, my lord, no dice has been mentioned. 2Z, my lord, of 2017 Act, my lord. It is only required for upper primary and lower primary schools, my lord.
Yes. Kaushik. We'll discuss it.
Yes, ma'am.
You were not considered by the district school.
Yes, my lord, district scrutiny committee. My lord, district scrutiny recommended, my lord. It was, my lord, not recommended by, my lord. By the, my lord, director, my lord. When, my lord, other teachers has been sent for provincialization after district scrutiny committee, my lord, the director has not sent my name. It was a page 37, my lord, where, my lord, other teachers has been provincialized. When I file an RTI, my lord, I came to know before because in the dice, my lord, my name is not located. Therefore, my lord, my name has not been sent.
So you're rejected by the state level scrutiny
Yes,
committee? Is that the case?
Yes, yes, my lord.
District Scrutiny Committee has recommended, my lord. It is there, my lord. At page, my lord, 34, my lord. Page 34, my lord. Paragraph starts from in continuation, my lord. Last line, my lord, if my lord kindly peruse. The proposal of the District Scrutiny Committee, Borpeta, has been examined and found that the service of the Bonale Borua is eligible for provincialization as tutor. In the subject, MI.
1 minute, page.
Page 34, my lord. Annexure 9, paragraph, my lord, first paragraph, last line, my lord. The proposal of the DSC, District Scrutiny Committee, Borpeta, has been examined and found that the service of the petitioner is eligible for provincialization as tutor in the subject MIL in the Anshalik College Junior Bongaon under Borpeta district.
We'll continue to.
Let's go on. Item 23, Lord, I have some urgency, Lordship. They are supposed to file affidavit. So let them file affidavit, let them come up. Okay, sir. Item 23, Lord.
What
I'm-
urgency is there? What urgency do you have?
No, Lordship, because of some problem, Lordship, I have to leave, Lordship.
But they call a council for petitioner. Mr.
GP Kumar.
If
4 weeks time to kind of
on request made by J. Pikul and the standing council.
elementary education.
Elementary department.
Education. For 3 weeks time is allowed to file contract.
Huh.
This up to 3 weeks.
Immediately after vacation.
After 3 weeks, you will
Oh.
come.
Offline, Lord.
No, Lordship, on Friday. We'll withdraw the other petition on Friday, Lordship.
So
No difficulty, Lordship. Let the matter come up immediately after reopening. But I'm not feeling very well to continue with our conduct.
Okay. Lordship, otherwise pleadings are complete, Lordship can reserve the judgment, Lordship.
no, he has not finished arguing the matter.
I have not finished my arguments.
But Mr.
And Gautam, Lord.
N. Gaudam and the council for the petitioner. Also heard Mr. D. Cycle and the advocate general Assam, assisted by Mr. B. Chowdhury, the standing council.
Lordship, for the university, all the respondents,
Appearing for.
for that KK University.
Appearing for. Heard them part. List for further hearing when?
Maybe on 18th or 19th, Lordship.
Read it, Lord.
It will be on 20th of July, Thursday. So in the meantime, they will withdraw it, Lordship.
Good, no, Lordship.
Highly obliged, Lordship.
Then if you are going to rely on some of those documents which are not in this.
Yes, I'll bring, Lord.
Maybe you'll have to file in affidavit.
Yes, Lordship, if required, I will file additional affidavit with advance copy to them. Deeply obliged.
Item 22.
My lord. Is it that matter? I was. Yes, please.
My lord, I have referred in judgment, my lord. Is
Where?
Kishore Kumar Nath, my lord. My lord has heard the matter, my lord. The issue has already been settled, my lord. The issue in this petition was that, my lord, my name was not in the dice, my lord. Therefore, my lord, my name has not been provincialized, my lord. I have placed in judgment, my lord, this order issue has already been settled, my lord.
Heard Mr.
As has the recommend.
S. Hazarikal and the council for the petition. Also heard Mr. B. Kaushik.
And because
I'm appearing for my lord.
Standing council.
1, 2, and 3, my lord.
Secondary.
Secondary education, my lord.
Correspondence 1, 2, and 3. 4 also, I think.
4, my lord, it's a deputy commissioner, my lord. 4,
For
advocate.
government advocate who appears,
G Pegu, my lord.
G. Bekul and the government advocate for respondent. Para. The petitioner was appointed as a lecturer at Anchalik College, Wittenberger Junior, Bangalore, in the subject of Assamese on 6/9/2010. Then what happened? The after the enactment of the Wittenberger Act of 2017 in short, steps were taken for provincialization of the teaching and non-teaching staff of the various colleges and schools in the state of Assam. Stop. With regard to the case of the petitioner, the district scrutiny committee, where's the recommendation?
My lord, pay is 28, my lord.
District scrutiny
My notes, my lord.
committee, in its meeting held on 8/4/2019,
Page 29, serial number 5, my lord.
recommended the case of the petitioner. Your Miss
Miss Bonali is Borua, my lord. Pay serial number 5,
for
Page 29.
provincialization, is in the Assamese subject,
Assamese.
against which school? Against the
Anchalik College Junior, Bongaon, my lord.
Panchalik Junior Bhawani. Stop. SLC did not consider you.
Not considered, my lord.
Thereafter, come.
Page 37, my lord.
No, prior to page 37 is this one, isn't it? Page 37 is second to fourth.
Page 34 is the, my lord. The director has sent my recommendation to the commissioner, my lord, on the basis of DSC, my lord. Page
The
34.
state level scrutiny committee rejected the case of the petitioner.
My lord.
Then you filed in RTI,
RTI, my lord.
being agreed.
Page 39, my lord, RTI.
Petitioner filed in RTI. What was the reason for the RTI?
My lord, page 39, my lord, it reason is that, my lord, in the dice, my name could not be located, my lord.
Cancel the plan. On the basis of an RTI application, the petitioner was informed that the case of the petitioner was not considered for provincialization, as her name could not be located in the
The
dice under Barpeta district.
Well-
So, Para. Then the counsel for the petitioner submits that under the Act of 2017, particularly with regard to Venture
Junior
Higher-
College.
Venture Higher
Junior,
Secondary-
junior college.
Venture
Venture
Junior
Junior College, my lord.
oblique Venture Higher Secondary Schools. The
Dice is not mandatory.
dice is not mandatory,
Mandatory.
and therefore this case could not have been rejected on the ground that her name did not appear in the dice. Stop it. Learned Counsel has also placed reliance in the case of WBC number in in order in WBC number 1353 of the 2022.
Page 23, my lord, does mean date, my lord.
Just like this. So place reliance in the case in an order dated 12/4/2023 passed by this court in WBC number 1353 of the 2022. It has been held that the name of the name of the petitioner should be captured in the dice code of 2009-2010 is contrary to the act of 2017.
Page 30, para 18, my lord, findings.
With reference to Venture High School and Venture Higher Secondary Schools. But you hear me? You can't hear me. You can't hear me. Can you hear me now? Yes, yes, there we go. Now, can you hear? So which part you didn't hear from the beginning? Which one? Okay, stop. In WBC 1353 of the 2022. This court, by the order dated 12/4/2023, held this under, stop, this under, then you quote.
My lord, page 30, para 18.
One minute. Quote para 12. A2A. Then you quote from para 12 points up to para 18. Para 18. Stop. Upon consideration of the order dated 12/4/2023. Passed in WBC 1353 of 2022. And the facts and circumstances of the present case in hand. I am of the considered opinion that the case of the present petitioner is poorly covered by the order dated so and so. Passed in WBC 1353 of 2022. In that view of the matter, shall we remand it back?
My lord, in the earlier order, my lord,
Earlier
it says
direction was
for
given in the-
verification, my lord. Para 19, my lord, it says for this and for verification, my lord. Pray for, my lord, similar, my lord, after verification, my lord, the authority. will decide.
Accordingly, this writ petition is disposed of with the direction to the concerned responsible authorities, particularly the Director of Secondary Education,
Yes, my lord.
Yes, my lord.
to consider the case of the petitioner for provincialization of a service as teacher and or tutor by making necessary verification. in terms of section 4 of the Act of 2017. And without insisting that her name should be captured in the DIS code of 2009-2008 or prior to stop. Let such exercise be completed within a period of
2 months, my lord.
2 months from the date of receipt of a copy of the order of sport. Stop. That must do with our observations in
My lord,
the.
kindly observe that, my lord, Venture Junior College also does not contain in section 2ZA, my lord, the dice, my lord. That, my lord,
Section,
section 2Z, my lord. The definition of Venture Junior College does not contain the dice also.
Court. Oblige, Lordship.
Oblige, my lord.
Item 1 of production list promotion. Jasmine Ara Ahmed versus State of Assam.
this matter has been listed on 30. So we'll list this on 30 also.
Yeah.
Yeah.
That though, my lord, it is also connected to MBBS, but the issue is not exactly identical.
This morning you said it is
Yeah,
exactly
yes.
identical.
Not
That's
to-
why I permitted you to move it unlisted.
I'm
If
not
it
sure
is
can-
not exactly on, I'm not identical, I'm not taking up the matter.
On 30th then, 30th, promotion.
Heard, Mr.
A Ganguly.
Learned counsel for the petitioner. List this matter again on 30.
Lordship.
24 of Delhi list. Admission.
Lordship, in this case, respondent number 4 have filed a affidavit in opposition, Lordship. I may be allowed to, 4 weeks time to file the affidavit in reply, Lordship.
Mr.
D. Burman.
D. Burman. Learned counsel for the petitioner. Praise for 4 weeks time to file reply to the counter filed by the respondent. Praise allowed. List up to 4 weeks.
25.
Highly obliged, Lordship. Okay, this matter may be adjourned for the day. And yes, advocate is not available.
Who's the engaged advocate?
Mr. J. Lashkar.
On
Out of
request
station.
made on behalf of J. Laskar and counsel for petitioner. List after summer vacation.
After vacation.
27.
My lord, in this case, case is arising out of prayer for granting, my lord, benefit under modified assured career progression scheme. My
MSc.
lord, petitioner is a grade 4 staff of the provincialized college. He is enjoying the benefit past financial upgradation, my lord, since 2011. Then, my lord, suddenly from May 2022, that benefit has been stopped by the principal of the college.
Affidavit has been filed.
My lord,
Affidavit.
affidavit by, my lord, of all, that my lord,
Director has filed.
respondent number
affidavit.
3 filed, but college did not file any affidavit. my
Who stopped the MSc?
College authority.
Who appears for college?
I'm for the respondent.
Are you
number four,
filing the
Lordship.
affidavit or not?
No, I have not filed the affidavit.
Are you filing or not?
Yeah, Lordship. 4 weeks time may be granted, Lordship.
All 4 weeks.
Or after vacation, Lordship.
I'll grant you 3 weeks time.
My lord, the date may be fixed, my lord,
No,
immediately.
I'm not fixing things. Heard, Mr.
J. Sharma.
J. Sharma, learned counsel for petitioner. On request made by MS.
D. Borpujari, Lord.
D.
Borpujari.
Barbujari, learned counsel for respond number
4.
4. 3 weeks time is allowed to file contract. List after 3 weeks.
Obliged.
28.
4 weeks may be granted.
My lord, this is non-payment of salary, my lord. Since September 2021, she is not getting salary, my lord. She is assistant teacher of a school, my lord.
Lord, we are yet to receive the instruction from the government. Director has given a report to the government, my lord, but it is pending since 22, my lord. I will try, let it be after vacation, my lord. I will try to get the instruction from the government. Pending.
Third MS.
NS Thakuria.
Ms. Thakurial and the council petitioner, Mr. Stinky, then standing council.
Secondary education, my lord.
Second.
That's new.
Place 4 and is granted 3 weeks time. This.
Highly obliged.
3 weeks.
Obligement.
29th order.
May I please, Your Lordship. Lordship, I is filed for correction, Lordship.
Who is the IA? IA is for what?
I is filed for correction, Lordship.
Correction of what? Correction of what?
In the cost title, respondent number 6, Lordship. The chairman, District Legal Scrutiny Committee, represented by DC Borbata. It will be DC Borbata, Lordship. In place of wrongly, I have written DC Dhubri, Lordship. And another mistake is, Lordship, respondent number 7, Lordship. Member Secretary DLSC represented by the Inspector of School BDC Borbata, pin so and so, in place of Member Secretary DLSC DDC Dhubri. It will be BDC. It will be BDC Borbata, Lordship. Accordingly, the wrong has been done in the order, Lordship. Order dated 24/11/2021.
21 yet come now. Anyway,
I've not got anything what you have said.
Lordship.
You want to change the
cost title of the respondent.
Repetition. Yes, Lordship.
You want to make corrections in the cost.
Yes, Lordship. And accordingly, the order in the cost title may kindly be corrected.
Whether that can be permitted at this stage.
Order dated 24.
No, wrong in the order, only the cost title was wrong.
No, in the cost title in the your writ petition.
Writ petition as well as order dated to 24/11/2021 in the writ petition.
Order dated 24/11.
2021.
What is the?
The respondents were wrongly mentioned. That is what he stated. Because in the repetition that was wrongly, he has stated wrong respondents here. That will automatically reflect in the order. That is
exactly. You can't have two at a time.
Yes,
First,
sir.
you'll have to change your cost title.
Yeah.
Then after that, you'll have to come for the correction of this. You can't have the cost title change and the same time they get the order change.
Lordship, at first I have wrongly written in the cost title of the writ petition. Accordingly, the order will be
But
the order.
Trustee,
yes.
here the legal service is involved. District Legal Scrutiny Committee, is it? Is it which one are the wrong numbers?
Respondent number 6 and 7, Lordship.
The chairman.
Respondent number 6, the chairman, District Legal Scrutiny Committee, represented by DC Borbata, pin number 781309, in place of DC Dhubri. Lordship, it will be DC Borbata.
Okay, then.
And pin number will be changed. And then, Lordship, respondent number 7, Member Secretary DLSC, represented by the Inspector of School BDC Borbata, pin number 781301, in place of Member Secretary DLSC DDC Dhubri. It will be BDC Borbata.
So serial number 6, 7.
And 7.
These two you want to change?
Yes, Lordship.
Only these two.
Lordship.
Only these two you want to change?
Yes. Yes.
These two, Lordship.
Whether the pleadings can be corrected by an IA, Lordship.
Not the pleadings.
The respondents were initially in the pleadings, they have wrongly mentioned, Lordship, in the cost title, not in the order. In a writ petition, they have wrongly stated.
No, no, no. Only the address he wants to change,
Address, yeah.
isn't it? So
Address
that's all. Once you change his address, there's no point in changing the order. Automatically, the serial number will be the same.
Is a new certificate copy, it will come in the corrected form.
Only Lordship DC Borbata in place of DC Dhubri and PIN number.
Okay, okay, okay. Heard Mr.
K Islam.
K. Islam, learned counsel for the applicant, also heard Mr. SMT Chishti, learned standing counsel. Secondary education for the respondents. 2, 3. 2 and 3. Stop. But his application. The applicant is praying for the change of address of the respond number 6 and 7 in the course titles of WBC number 6147/2021 on the ground that there has been a typographical error. Stop. It is submitted that respond number 6 should read as the chairman, district level scrutiny committee represented by the deputy commissioner, Barbeta, Assam, PIN number
PIN number 781309.
781309. And the respond number 7 should read as the member secretary, district level scrutiny committee represented by the inspector of schools, DTC,
Borbata.
Barbeta, PIN
PIN 781301.
301. Stop. On perusal of the course shown para and on hearing the learned counsel for the applicant. The prayer for correction of the address of respond number 6 and 7 in WBC number 6147 of 2021 is allowed. Is disposed of. In the main petition, in view of the order dated so and so, let the address of the respond number 6 and 7 be corrected as, then you keep the same one, okay? Registry is directed to do the needful. List the matter after the summer vacation.
Developers.
I use this one. Huh? Oh. Oh. This is dispersed. Where's the gentleman?
It is a disposal of matter. That is why I am saying.
I didn't know that.
Yes.
Is it disposed matter?
Yes, Lordship.
Oof. Then you'll have to file.
That is what I said, Lordship.
I didn't get you.
Yes.
You'll have to file a review. Or miscellaneous application, not this.
Then mechanically referred as appropriate bench, Lordship.
Huh?
Appropriate bench. Sorry, Lordship.
Next.
You withdraw this with liberty to file afresh. This is a disposed matter.
Yes, matter, Lordship.
Then cancel the order. What do you want to do?
Adjourn today, Lordship.
Huh?
Adjourn today, Lordship.
Withdraw
My
it.
senior will argue the matter, Lordship.
Yes?
Adjourn today, mechanically adjourn today, Lordship. My senior will argue the matter.
Okay. On request made by Mr.
K.
Yes,
Islam.
Islam, list the matter of the summary.
30.
In the item 30 lawsuit, I have passed the compliance order lawsuit. That is the, we have already complied with the direction of this honorable court lawsuit. Any service has been provincialized, that order is given. Last order, yes.
This is on June 23. Therefore, the claim of the petitioner is found to appear in die publication data union against.
কৃষ্টিদা এই আমোৰটোৰ কথা একো নকলে যে
আমার জন্য কথা বলে।
না আপুনি লাগতে আৰু কিন্তু মোৰ
Yes, Mr. Talukta.
My lord, this order has been given. In fact, one thing, my lord, I don't find that there is a cancellation of the other one, but my provincialization is not, my lord, spelled out. That is what I'm finding from.
It's in the second last paragraph.
Yes, everything is there, lawsuit. We have to go through it minutely, lawsuit.
That is what I'm trying to find out, my lord.
Whatever it is, the substantial compliance of this court's order.
Yes, yes.
isn't
No,
it?
no, I have found it, my lord. The hearing committee suggested that the claim of the petitioner for provincialization service may be considered as per order dated 16/6/17 has already been issued, that he is liable to get all benefits of the service as assistant teacher of MEM and may be considered for provincial service. Yes, that is there, man.
Correct. I'm closing it.
Yes, yes, correct.
Mr. S.K. Talukdar, Learning Council for the petition. Submits that they have, that the respondents have complied with the order passed by this court.
The service.
He also furnishes, he has also furnished the order dated 26 June 2023, issued by the.
Considered.
Cancel it, huh? Mr. S.K. Talukdar, Learning Council for the petition has furnished an order dated 26 June 2023, issued by the Director, Elementary Education, Assam.
My learned senior has produced, my lord.
Anyway, you, both of you, you have got.
Yes,
it,
yes,
isn't
correct,
it?
correct.
So
I have
that
got it,
I
my lord.
suppose that the respondents have complied with the order. passed by this court. Recording the submission.
I
and
will do.
the council for the petition.
Maybe considered as part of it.
This conduct
To get all
business
benefits.
laws.
Maybe considered for
Assembly
provision.
Order
chief
sole container.
The council appears on behalf of the sole respondent.
Obliged.
I'm saying you're furnished.
Right.
Same thing, makes no difference.
31.
May I please, as your lordship?
What is this?
My lord, in fact, in the main writ petition, my lord, the transfer order which was under challenge, my lord, had been revoked. So basically, my lord, the main writ petition goes, my lord. But my lord, what has happened? The headmaster of the concerned school, my lord, by this way or that way, is taking coercive action against the petitioner, my lord. Some, my lord, relief in which I prayed in the, my lord, IA. My lord, may be pleased to find the prayer part at page 11, my lord. During the pendency of this, my lord, writ petition, such type of, my lord, coercive action had been affected. That's why, my lord, this
The
honorable.
writ petition.
No, my lord, in the interlocutory application number 1766.
Yes, page 11.
My lord, page 11, my prayer is the parties, my lord, the SKRAM allow the applicant to work as an assistant teacher of the school in a peaceful and conducive atmosphere without causing any undue atrocities and oblique or harassment to the applicant. My lord, what has happened, my lord, as my lord, the headmaster of the school, as per my instruction and the petitioner statement was the, my lord, party is involved while, my lord, succeeding in my transfer, my lord. Now, when, my lord, this honorable court was pleased to interfere with the transfer, then the headmaster, being the headmaster of the school, my lord, is now inflicting some atrocities upon the petitioner.
What atrocity?
My lord, I have. My learned friend was about to obtain instruction. Perhaps he has the instruction, my lord.
Lordship, the allegation I have obtained oral instruction. All, everything is incorrect. Lordship. All the allegations are incorrect.
So disputed question of facts.
Yes. And Lordship,
Not
his main
disputed, my lord.
grievance has already been
My-
addressed. Lordship, his main grievance has already been addressed. That order has been revoked by the authorities. Lord.
Then Bhuyan,
My lord, it is not disputed, my lord. I have made certain representations, my lord. My representations are, my lord, may be pleased to find at page 26 of my IA. This has also not been forwarded by the headmaster of the school. Secondly, my lord, at page 28 is a, my lord, prayer made before the headmaster of the school.
Actually, the main
My
grievances are-
main grievance, my lord, transfer, I have, in the very beginning, I have said, my lord, that the transfer order has already been revoked. Now, my lord, during this pendency of the writ petition, these are the developments, my lord. It happens, my lord, in such type of situation, my lord, when the headmaster fails this way, and then that way, my lord, in indirect manner, my lord, he wanted to, my lord, press me out from the school, my lord. Being the drawing and.
KL, you are appealing for?
I'm for the headmaster.
Headmaster.
Respondent number 4. Lord.
And his grievances against the headmaster only.
And my lord, obviously, my respected senior friend is not going to admit all these, my lord. He cannot admit also, my
Do
lord.
you want to keep this
My
pending?
lord,
or-
my lord, these representations can be disposed of, my lord, by the authorities, my lord.
By the Lordship Inspector of School has to, if he has any grievance against the headmaster, he can approach the Inspector of School. And his main grievance has already been addressed by the Inspector of School.
Yes, yes.
And if he is
Then
in,
you can address the inspector.
Yes,
of-
my lord, that observe, my lord, may be
he can
pleased to
approach-
observe that, my lord, if any grievances is there, I will approach the director of secondary, my lord. And he will pass, my lord, he will take necessary action in this regard, my lord.
In the main writ petition, you write.
My lord.
Mr. A. Bhuyan and counsel for the petitioner. Submits that during the pendency of this writ petition,
My lord.
the respondents have withdrawn.
My lord, actually, due to the interim order passed by this honorable court, they have withdrawn, my lord.
Who is the order?
My lord may be pleased to find.
Impugned order?
My lord, my lord.
page 31, Annex 2.
The impugned order, my lord, is at page 31, annex 2, my lord.
Have they've withdrawn this order, is it?
Yes, yes, my lord. Subsequently withdrawn.
Withdrawn the order dated 22/12/2021.
Okay.
And therefore, within the order, it is sent. And therefore submits that the matter has become infectious.
My lord.
He however submits. Do you want that recorded or not?
My lord, they,
Or you want to quietly approach?
my lord may observe that the, my lord, grievances which has been raised in the IO, the same grievance I will raise before the director of secondary
Yes,
education.
not. Accordingly, this writ petition is disposed of as infectious. Subpara. The grievances raised in the connected
My
IA,
lord, I am, my lord.
which the grievances which the petitioner has raised in the connected IA number
My lord, 1766.
1766 of 2020.
My lord.
The same may be raised before the concerned inspector of schools.
No, my lord, director of secondary education.
Before the director of.
It should have come from the inspector of school. That
No,
would be
let
better.
it-
But from
let-
district,
let
it should
it
come
go
to the
before the
director. Yes,
inspector
Lord.
of schools. Don't go directly.
Yes, Lord.
Before the
Fine.
inspector of schools, which district?
My lord, it is Karimganj district. sir.
Karimganj district.
My lord.
With the above.
I am appearing for the respondent number 4.
My lord.
Mr. SCKL, then a commissioner appears for respond number 4.
And for the
Mr.
department,
SCG,
second year.
Whereas standing council appears for the second.
My lord, the Karimganj inspector of school will do the needful, my lord, if I approach the same, that observation, that direction. may be taken.
The petitioner approaches the Inspector of Schools, Karimganj. They said. in the
Address
complaint
the
of-
grievance and pass a reason order.
No, I'm not special.
My lord, my lord.
No, I'm not- may I approach this, that
Mal.
one only.
Oblige, my lord.
I will also discuss.
32.
May it please your lordships. My lord, there is an IA, my lord. I would not like to place this petition. my lord.
MSK Devi, learned counsel for the petitioner, submits
I may be closed, my lord,
that she has instructions not to press the present IA.
and I would like to,
Accordingly, this IA is disposed of as not pressed.
for which time may be granted for
Into the
reading the present
present.
incumbent.
In the contempt case.
Yes,
Yes,
my lord.
in a main case.
MSK Devi, learned counsel for the petitioner, prays for 4 weeks' time for making an appropriate application.
Highly
Oh.
advised.
Infringement of parties. Stop. Praise the Lord. This after 4 weeks.
33.
Lordship, here an order passed in the year 2019 is yet to be complied with. Very limited relief, Lordship, the facts are that the period of suspension was regularized, but only the 70% that was on the 25% balance arrear salary that remained due, that was not released. The direction, Lordship, at page 11, if your Lordship takes up page 11. Last page 11, last
Of
paragraph.
the IA. Or
No,
the
no.
contempt.
Lordship, the petitioner has expired and the legal has have substituted themselves in this matter for pursuing the
That order has been
case.
passed for.
Yes, substitution already passed. That is passed.
In the contempt.
Yes, contempt. That has been disposed of.
No?
If your Lordship takes up page 11 of the contempt application.
Has the substitution been allowed?
Yes, yes, substitution allowed. Allowed on
When was it allowed?
23/9. 27.
It is not.
27/9. Lordship, if Lordship peruses 19/10/2022, probably there on 19/10/2022. IA number 2994.
I am.
2994 of 2022.
Order date?
Lordship 19/10/22, probably 19/10. And my record.
19/10/22 said heard MSD Burgoyne Learned Counsel for petitioner on request made on behalf of NJ Khatania. List the matter on 21/10/2022.
Oh, Lordship, what had happened was Mr. Katonia was appearing for the respondents. In fact, he had placed certain instructions at the district level. Some developments were going on. He had in fact assured the court that they were petitioners were to. That is why the matter got adjourned. If Katonia answered,
Matter may be taken up after vacation.
Katonia, he has got the necessary instructions, Mr. Katonia.
Burgoyne, you better check up whether your substitution application has been allowed. Because no order has been passed. And there's no change in the course title.
Lordship, if there is no such order, then Lordship can at least pass necessary orders allowing the
The only,
substitution.
only question is who's appearing on the other side? Because
They are there. The original the contemners are there. Ms. Sakia is also there. Yes, he is one of- No, the advocates are there. Advocates, we want the advocates are here. The councils are representing the opposite, the respondents. Councils are present. Substitution probably not much of an issue because the councils are there. This can be at least allowed then. In fact, Mr. Khatoniar had in the instructions. That is why this matter got adjourned from time to time. মাতিব পাৰিবা নেকি তাক?
How many legal heirs are there?
Lordship 5.
Without impeding the present respondent, if the substitution is allowed, Lordship, that is also Lordship may kindly look into.
The substitution was filed.
Because those respondents were no longer in service. Now you want to substitute with the new,
No, but
the present
the
respondents should have been made a party. Lordship.
contempt law is that the existing containers cannot be absolved of the contempt
That
liability.
is true.
Who is Khatania?
He is in the court. He is there in the court premises.
His presence is required.
Oh.
Yes. Okay. Then we'll
I
list
have
it
to
up
ask
in
him.
summer vacation.
Lordship, yes,
Take
sir.
up this issue because see, until the substitution is made, nothing will happen.
Yes, my lord. Lordship can allow
But then
this.
are you appearing in this matter?
Yes, my lord.
You are appearing?
For the earlier.
They are appearing, their names are reflected in the causes. They are representing two of the.
Is no longer in the office, my lord. He has
That
already
cannot be a
retired, my
submission.
lord.
That
And my lord, another thing
That's
is
fine.
that today is for the IA, my lord.
yes,
why
that is
only
why
I-
the IA can be allowed.
The IA will be allowed,
Substitution, no? Substitution to 12%, no objection to it.
See,
Substitution also
substitution
mine.
can be done and
No,
after
but
that she can again have
Yes,
to have
that
to
is what we are saying, as it
implement
is there
the
representing
new
the council.
parties.
But my lord, Pitam Soika already retired, man.
That's fine. That we know.
With lordship, even if we have to implement the new
Because
incumbents
see,
on.
if the implement of new incumbent is to take place first,
My-
then she'll have to again withdraw this IA. Because all the things are wrong in the IA.
Yeah.
It's as per the original list of in the contempt petition. So what this court is thinking, allow
Yes.
the substitution, later make the implement application later on,
Yes.
then proceed.
Yes, yes, that is what I'm on. Unless and until we are allowed to be implemented, we cannot take further steps.
Yes.
There'll be no one to take further steps. So let that be allowed, then we can file implement applications.
See, Furqan, petitioner has already died.
Yes,
There's nobody to make the implement.
My-
All right. Nobody to, unless they are substituted in the contempt. After they are substituted, only they can file the case for implement.
Lordship, I do not understand why they are objecting to this simple prayer. They have to, it's a,
I'll allow,
yes.
I'll allow the substitution. After that, let's make application.
Matter may be taken on 13, my lord.
What?
After tomorrow. my-
What day after tomorrow,
I will
Lordship,
inform Kutonia.
Lordship, what will be the adverse consequences of allowing the
Today-
substitution application? I do not understand. Oh, they have to assist the court at least. They are also the officers of the court. This is the only logical procedure.
My lord, I am appealing on, yes, my lord, I am appealing on behalf of respondent one. But matter is handling by Mr. N.J. Khatonia.
What kind of
Today
a
he is
submission is
not
that? Her name
available now, my
reflects.
lord.
Where
What
is,
can I do?
where is NJ Khatania?
N.J. Khatonia.
Mr. Tishi's name is also reflected in the causes. He also represents one of the contemners.
One is already retired long back.
I understand.
Now, how can
That is
I-
what even the honorable court
Even,
appreciates that he
even
has
for
retired.
substitution, how can I justify?
No, even the honorable court understands
Showing
that he
name
has
doesn't
retired.
mean
What
that
we
I
are
have to
trying-
appear.
What we are trying to say is that the contempt law is that one cannot be absolved of the contempt liability on retirement. The liability continues. That is the contempt law. And Lordship, the allowing of the substitution will not
Let's wait,
have any
let's wait
adverse.
for Khatania to come.
Even her name is Lordship reflected. I do not understand why they are objecting to this
simple prayer, innocuous prayer in fact.
Who appears for respondent two? Fukan, you are appearing for one.
Yes, my lord, I'm appearing on behalf.
And
of
Chishti,
Respondent one, madam.
Actually, my name was shown here by this honorable court also because I have not filed any Okalnama. Because as I've appeared continuously appearing in all the cases, so my name was reflected like that, lordship only.
okay. Okay, heard MSD Borgohain, counsel for the petitioner. For the applicant. Also heard MS N Fukan, Leonard, counsel appearing for the respondent number one. Stop. Para. By this application, the applicants who are the legal heirs of the deceased petitioner in contempt case number 608 of 2022 are praying for substituting the deceased petitioner in the said contempt petition. Stop. It is the case of the applicants that the petitioner in the in contempt case number 608 of 2023 expired on 27/11/2021. Stop. And that the course of and that they would like to pursue the contempt petition. Stop. But after hearing the parties, the no. So don't say like that. The applicants.
Please, non.
Khatania, you have for respondent number?
Right. Respondent number one, my lord.
How many councils are there for respondent number one?
But in cause list, it has not been shown, my lord.
Substitution can allow to
That's it, the applicants, namely, then page 3, A to A. Are praying for a substitution of this one to continue. The prayer for implementation is allowed, the prayer for substitution is allowed. In the contempt case, in view of the order passed today, so let's so and so, right from 1 to 5, this substitute the present petitioner, the petitioner who has passed away on
27/11.
27/11/2021. Stop. MSD Borgohain and the council appearing on behalf of registry is directed to do the needful. MSD Borgohain appearing on behalf of the legal heirs of the petitioner. Prays for another 3 weeks' time to file an appropriate application for implement of necessary parties. Prayers allowed, list up to 3 weeks.
Obliged, lordship.
34.
May please your lordship. In this implement petition, lordship, there are two numbers of incumbent. One is lordship commissioner secretary to the secondary education, and another is the director of the secondary education. Now the question is that lordship, yesterday I came to know that the commissioner secretary was retired and another was come. So, but lordship, director secondary education is
1 minute. Whom are you trying to implement?
respondent number 3 and 4. Lordship, page number 4, lordship.
Then you file afresh, withdraw and file afresh.
No, lordship, there are two numbers of incumbent. For one, lordship, I will file the implement petition, but partly allow this petition, lordship, because Mamata Hujai, who is the director of the secondary education,
That is right.
is now
But
here.
other one is
So
wrong.
lordship, kindly
Now
partly allow-
Mamata Hojai will be implemented as part of respondent number.
4. As respondent number 4, lordship.
Why you complicating matters?
Better file, একটাতে file করা। এটা ভালো, নহলে
Why
নিমিলিব,
you
serial to will be
complicating
disturbed.
matters?
Serial to নিমিলিব নহয়।
না মিলিব সিরিয়ালি আছে There is serial as respondent number 4, Lordship.
You have only two respondents.
We have only two respondents, number Pritam Shaita and Jidin. Those are retired, but or otherwise transferred. On this place, the new incumbent respondent number 3, Bijay Chaudhary, and Commissioner Secretary, and respondent number 4, Mamata Huja, Director. Now, Lordship, if Lordship allowed the Director of the Secondary Education, then he is the respondent number 4. And if we have to file the other impleadment petition, press impleadment petition, then Dr. Bijay Chaudhary, in his place appear one another person. He is as respondent number 5.
How many respondents are there in your contempt petition?
Mainly 2.
After that, from where the 4 comes and 5 comes?
Three.
What happens to 3?
3 is a Commissioner Secretary. I have already mentioned. Then Lordship, it's okay, Lordship. Then Mamata Huja is the respondent number 3 because he is already retired.
I don't know. Why are you complicating matters?
Lordship, kindly see page number 4, Lordship.
I've seen everything.
Yeah.
But Miss MS,
And they
learned counsel for the applicant. By this application, the applicant is praying for implement of MS Mamata Hodai AS, Director of Secondary Education, Kahilapara, Guwahati, 19, Assam, as party respond number 3 in contempt case number 492 of 2020, on the ground that the respondent number 2
It's already been
has
transferred.
already been transferred, and the proposed respondent is holding the post of Director of what?
Secondary education.
Secondary Education. Stop. After hearing parties, after hearing the learned counsel for the applicant, prayer for implement is allowed. IA is disposed.
They have to implement the respondent 1 now.
In
Again.
the contempt. But in view of the order passed today, in IA so and so, let so and so be included as party respond number 3. Registry is directed to do the needful. Petitioner to take steps for service of notice on the newly included respond number 3 by registered post PKB within 1 week from today. List the matter after 6 weeks. After that, you'll have to come for implement. After that, notice will be issued, returnable in 6 weeks. That will make things longer for you. That's what I was
Yes, yes,
telling.
definitely.
If you have withdrawn this and come,
Both the cases.
35.
then
it's your choice. I've already dictated. I'm not withdrawing my order. Yes.
same thing, Lordship. There are 4 numbers of incumbent. One is retired. That is respondent number 4 in page number 5, Lordship. Then I withdraw.
Yes. IA.
Withdraw করে দেব না?
উইথড্র করে একেলগে ফাইল করা যে বেটার
Lordship. Then Lordship, I agree to withdraw both the cases.
Huh?
Now you want to withdraw this IA to file a press 1
Of phrase
correcting
one.
the name of the present secretary.
Okay, Lordship.
MS.
In both the items.
নাম তো নাম তো
34 and 35, Lordship.
MS.
And they.
Learned counsel for the applicant press for withdrawal of the present IA with liberty to file a press. Press allowed, IA is disposed on withdrawal with liberty as paid for. Same order in the.
In earlier also
in
lost.
the early-
Yes.
Oblong question.
36.
36 করছে নাকি?
May I plead your
Yes.
Lordship, this is contempt petition.
New case.
New Lordship. Honorable Court order passed on 15/2/2023, page number 17, Lordship.
What direction was passed?
Mainly two direction.
Did you file your appeal?
I'm the senior most language
Have you filed your appeal or not?
Appeal file. Lordship.
When did
Appeal
you file?
filed on dated 23/2/2023.
23 to 2023. Okay. 2 months. Okay, heard, Mr.
M. Hussain.
M. Hussain, Learned Counsel for Petitioner. Issue notice. Petitioner takes steps for service of notice and so responded by registered post AD within 1 week. List after 6 weeks.
Obliged.